I seek your Lordship's indulgence in mentioning item number 5 of part 2, your Lordship.
Item number 5.
Yes, your Lordship.
Part
I've taken the consent of the opposite party if this matter may be listed again after a week, your Lordship.
Item number 5. RFA 11.
Yes, your Lordship.
Okay, on a request made by the Learned Counsel for the respondents with the consent of the counsel for the petitioners, list this matter again after a week.
Yes, your Lordship.
After a week in the hearing list. Yes.
Much obliged, your Lordship.
Yes, sir.
With your Lordship's permission, Your Lordship, there's item 6 and 7 in part 2.
Okay.
If Your Lordship will see the last order, there's a matter pending in the Supreme Court dealing with the subject matter of these two writ petitions.
Okay.
This is regarding the decision of the respondents to outsource the services of the petitioners who are engaged on contract basis. So now the respondents have taken a decision to outsource through government e-marketing.
Okay.
So that is under challenge in the Supreme Court. In fact, as per the Supreme Court website, the matter is to be listed today. So if this can come up next week, Your Worship, anytime. If it is disposed by the Supreme Court, then it will be a covered matter.
It has been submitted by Mr. A.R. Malhotra, Learned Counsel, appearing for the petitioners that the subject matter of these writ petitions are under consideration before the apex court. Full stop. He further submits that the matters are listed to be taken up today. In such view of the matter, he has prayed that the matter may be fixed in the next week, awaiting outcome of the litigation before the apex court. Full stop. The Learned Counsel for the respondents do not object to the same. Accordingly, let these matters be listed in the next hearing list, in the hearing list for the next week. Full stop. Yes.
May I seek your Lordship's indulgence in making a mention with respect to part 2, item number 11, my Lord.
11.
Yes, I have
Yes.
taken consent from the opposite party, my Lord. If this matter may come up on Thursday, day after tomorrow, my Lord, if permitted.
Do we need to pass an order? You can call it day after tomorrow. Yes, call it day after tomorrow.
Oblige.
I seek your Lordship indulgence in mentioning part 2, item number 16.
16, yes.
Yes, my Lord, my senior, I'm mentioning on behalf of my senior, the amicus curiae. He has some personal difficulties and have taken the consent of the learned APP. If this matter may kindly be taken up after 2 weeks.
It has been submitted on behalf of the learned amicus curiae that he is not in a position to appear before this court today. Full stop. Accordingly, it is prayed that the matter may be taken up after 2 weeks.
My Lord.
Full stop. Learned APP has consented to the prayer. Full stop. Accordingly, list the matters after 2 weeks
Deeply
for
obliged.
hearing. Yes.
May I seek your Lordship's indulgence in mentioning part 2, item number 9?
Number 9.
Yes, my Lord.
Yes.
Criminal appeal. My Lord, I have taken the consent of the opposite party, and if this matter may kindly be taken up on Thursday.
This is a 2023 matter. Is it against conviction or something? Is the man behind bars?
Yes, my Lord.
He is behind bars, the accused.
Yes, my Lord.
When do you want it?
I'm sorry, my Lord.
When do you want it?
On Thursday,
Thursday,
day after
okay.
tomorrow.
Okay, Thursday. Yes, Thursday.
Daily list for admission, item numbers 1 to 6.
My Lord, I was supposed to obtain instruction in this regard. Then I received instruction in this morning in the premises of this court. However, my Lord, that instruction was not in consonant with this honorable court order. Then I may be granted a week's time for obtaining instruction afresh.
What was the requirement of this court?
Yeah, my Lord, the latest update of payment of acquisition.
Same as in the process. You are appearing for the respondent number 3, 7 and 9.
Yes, my lord.
So at what level is it pending?
My lord, that is why I am just given instruction relating to the brief history of the case.
So they have given you a brief history.
Yes, my lord.
And at the end of it, they may have given you the status, maybe, the last paragraph?
In the last paragraph, my lord, their stated recommendation, they recommended for file appeal against.
file
the
appeal
judge.
now.
Yes.
This is of 2019.
Yes, my lord.
What was the order passed by this court? See, we may be required to pass strict orders because if you have page 24 of the contempt petition, it says keeping in mind the fact that 10 years had elapsed. That was sometime in 2018. Now we are again more than 6 years after that.
However, my lord, the conclusion has been made in this year only. Conclusion, finding has been made by the verification team only in this year, my lord.
No, the orders of this court was of 2019.
Yes, my lord.
Now they taking their own sweet time, they are not praying for an extension before this court. Simple methods. An application before this court that yes, we are trying to do it and we need some more time for this. But yes, what do you say? They are asking for more time.
Lordship, even though I'm not,
You are in which matter?
I'm
All these arise from the same order.
Same,
My lord,
same order.
same order.
Same road, same stretch of road.
2 to 15
Hmm.
is my case.
Hmm.
And in the case, Lordship, as you know, writ petition was not challenged. According to the writ petition, as the calculation was made, and firstly they have made, however, the multiplication is changed, and again they have made a word. And it's pending for quite a long time, even in contempt.
Any- Are these officers still there? This Brigadier Birender Singh, M.N.
No, my lord,
Ansari?
a new incumbent officer was there.
Okay. In 2023, this SP Kolipe and their Deputy Commissioner, Project Pushpak. Yes, how much time would you require?
My lord, to obtain instruction, my lord, 1 week's time may
It's
be
not
given.
not about obtaining instructions. See, the Deputy Commissioner has filed their show cause. The respondents have not. Contempts do not proceed on instruction for a very
My lord,
long time.
In the meantime, my lord, we have a new chief engineer, GP Singh.
No, the earlier engineer, what he did would be still a question.
Yes, my lord.
We cannot be pressurizing the petitioners to implead new respondents, and the earlier ones, they go scot-free. It cannot be so. They have to answer to the court. So there is no affidavit filed by whom?
Filed by the earlier chief engineer.
Respondent number 12. Yes, who all have filed the affidavits? You have to tell us. Who's appearing in item number 1?
Respondent number 9.
Just a minute. Who's appearing for the respondent number 1? Are you appearing for someone, madam? No. Huh? No, let us go serially. Respondent number 1, Chief Secretary, Government of Mizoram, who represents?
Your Worship, I represent the states of the sorry, the Deputy Commissioner Siaha in the matter.
What about respondent number 1?
Your Lordship, respondent number 1 is, we, notice
Let us put this thing in order, then we can first find out respondent number.
number 1 is not in, the present incumbent anymore.
But he was there.
He was there, but then
So-
compliance is made by the states, state respondents.
Okay,
Now-
just no, I'm just trying to find out who are the people who are required to reply here. So you say respondent number 2 has filed a reply? Who has filed the affidavits now? Okay, affidavit of Dusty, reply by respondent number 6 is done, respondent number 2, additional affidavit by 6, 7,
8,
3, then 8, 7, 10,
12.
11, 12. These people have filed.
Yes, those are the state respondents.
Nine is still holding the post, madam?
9, SP Kulipe.
Chief Engineer Project Pushpak?
Yes, my lord. Now we have a new chief engineer. Later
Who
on,
is
we have
4?
another chief engineer.
4, okay. We need a reply from 4, that is Chief Engineer. 4 and 9 would do the same, hai na? 4 and, no, sorry, 3. 3 has filed a reply. What does 3 say? Instruction. Here it is being very taken lightly. 7.
My lord, the respondent number 3 and 7,
Who is 3?
3 and 7 have filed a joint affidavit.
How can they?
This is the
In a contempt, how can they? And where is the name of the deponent in the cause title? Kindly show us.
this yes.
Who is the respondent number 3 in the contempt petition?
Brigadier Virendra Singh, chief engineer. Project.
Okay, and who is 7?
7 is a new chief engineer.
What is his name?
Prasad.
Manav Prasad.
Madhav Prasad.
Yes.
And who has filed the affidavit in opposition?
This is
Respondent
by Prasad.
No. Who
Manav
has
Prasad.
filed it?
Prasad.
Manav Prasad.
I so and so?
Manav Prasad.
Where is it? When was it filed?
This is filed on 4/6/2021.
4?
4/6/2021.
6/2021. Okay. Manav Prasad. Okay. He is 7, so 3 has not filed it. This was filed on. Yes, have you gone through that affidavit of Manav Prasad?
My lord, at page number 4, it basically says that since the genuineness of the land parcels could not be ascertained, so payment of compensation as well as acquisition of petitioner's land does not arise. That is the version of the respondent number 7.
My lord, in fact, the writ petition has been disposed of for spot verification only. However, the spot verification team could not ascertain the genuineness of the land parcel of the petitioner.
Where is that order?
The order is
Where is that order? Yes. If the petitioner's land passes, page 23, please read.
Page number 23, paragraph 2, sending the verification report by the Deputy Commissioner to the other respondents. The respondent number 4 shall take a decision with regard to whether the land parcels of the petitioners are valid and genuine.
No, read from, I think we should read from para 8.
Para 8.
Para 8, no, para 7.
Para 7, 20, page
What were they required to do?
The land counsel for the petitioners refers to the order dated so-and-so, passing by this court in WPC number so-and-so, which is annexed at Annexure 7 to the additional affidavit filed by the petitioners on 9/5/2019. Upon perusal of the same and considering the fact that the present case is a covered case, the writ petition is disposed of by constituting the following verification team.
So this verification team was constituted, there is no doubt?
My lord,
Verification team was constituted.
my lord.
Then what the verification team shall, within a period of 2 months, convene a spot verification of the petitioner's land. Has that spot verification been done? Yes, for the Deputy Commissioner, kindly trace out from your affidavit the verification report, if you can have that.
later on.
Your Lordship,
My lord, spot verification has been conducted many times. However, they could not ascertain the genuineness of the land parcels of the
No,
petitioner.
before we come to the BRTF, that is your
My
border
lord, later
organization,
on,
we want to know from the Deputy Commissioner, it is a Deputy Commissioner who was required to forward the verification report to all the respondents. Has the Deputy Commissioner done that?
yes, Your Lordship. Your Lordship, in fact, the joint verification was done way back on 16th October 2019. which is-
Just a minute,
which
16
Your Lordship may find from
October
the affidavit of
2019.
Respondent number 2. Respondent number 2. Yes.
affidavit of respondent number 2. Okay, we'll try to trace it
So
out.
after this, the main contention was that in some of the cases, the direction of this honorable court was to verify the land holdings of the petitioners. Now, so as to verify the land holdings of the petitioners, the keeper of the records, the land passes, was the senior revenue officer of MADC. Now, it was at that point of time they have lost the record.
Okay.
So the passes cannot be ascertained as to whether it's genuine or not. And time passes 1 to 2 years, and then land passes was reconstructed by the MADC authorities, and then it was submitted before the district deputy commissioner, and then it was amicably agreed that okay, we will agree to we will accept the reconstructions. Now, after the reconstruction was accepted by the authorities, then notification was issued for acquisition. And
Okay, now let us concentrate on the order. We are in contempt jurisdiction, not in writ jurisdiction. We will not go to decide issues, we will try to find out whether the order has been complied,
Yes.
and if so, to what extent. Now at page 23, the Deputy Commissioner shall take a decision with regard to whether the land passes of the petitioners are valid, genuine passes. Do you have it at page 23, para 9
Yes,
of the order? So you say that part has been done.
yes.
The petitioner shall produce the original land passes for inspection and verification. If the petitioner's land passes are valid and give heritable and transferable rights to petitioner, the respondent shall therefore take a decision whether they want to vacate the petitioner's land on which the road is constructed or acquire the land. Now, so till this part, the petitioner's land passes are valid and give heritable and transferable right. According to the Deputy Commissioner, they are valid passes. There is no problem with the land passes. Yes. Now the respondents are to take a decision whether you want to acquire or you want to vacate.
Your Lordship, fast forward, in between there are many affidavits that is filed by the incumbent, incumbent. Now fast forward, if I may take Your Lordship kind attention to the short post reply affidavit filed by respondent number 12, which was
12.
filed on 22nd May 2025.
22nd May 2025.
Yes. This is filed by the present incumbent, the Deputy Commissioner.
Is it here? Where is it? Hi, please, please. That's 105. This is 21. This is 22. Then this is 22. 18 pages they are saying. Where is it? Please take the file and find it out. Is this the one? No. No, this is 23. Find out, maybe additional file or something. What does that say? That affidavit we are not
Yes.
being able to trace out.
It says that his predecessor has conducted a spot verification, and after that, reconstructed land reports was accepted, and after that, they issued an order declaring the passes of the petitioner as genuine. That is in 8/5/2023. And after that, it was sent to the other respondents for further necessary action. And accordingly, preliminary notification for land acquisition was passed, and it was duly approved by the state.
So till that stage, your Deputy Commissioner has done what was required to be done.
Yes, yes.
Yes, after 2023, madam.
Lordship, even award also already made, assessment made, award also
Ah,
already
yes,
passed.
this is the one. Kindly see. Is
Award
this the
number
one?
12 of 2024.
Huh? 22nd of May 2025. This is, what is this? Who is it? See? This is the one. So let us see. Deputy Commissioner, this is, you are talking of the affidavit filed in contempt case 21 of 2019.
No, Your Lordship, in 16 of 19, in 16 of 19, that's item number
Who is the person who has sworn it?
V.R. Schweizele there, is there.
My lord, I have received that same copy on 15/5/2025. I have received copy.
22nd, 5,
Yes, yes. It is by Mr. V.L.
Schweizele.
Roizela. है ना?
It will start, the action taken will start from paragraph number 4 of the...
Number 4. Acha. Then what happened? When was this file? 22/5. So Deputy Commissioner has filed it on 22/5. When was the award passed?
It's in 2024. And then after that, some reassessment was made.
Yes, madam, now that you have received the award,
We received a white letter dated 29 May 2025.
yes, now after that report was sent to you,
Yes, my lord.
you were required to take a decision either to vacate or to acquire.
Yes, my lord.
Thereafter, you were required, if acquiring, then you were required to make the payment.
Yes, my lord.
Simple order.
Yes, my lord.
If you want to vacate it, vacate it. If you want to make the payment, you have to make the payment.
Yes, my lord.
Now, by when? Tell us that.
That is why I was directed to obtain instruction, the latest update of the payment process.
Ah.
However, instead of giving me that latest update,
Who is the person who has signed it?
my lord, there is no any forwarding letter. They just gave me in WhatsApp, then I print it out. Because I resigned in the premises of the court, I just received it, my lord.
Today.
Yes, my lord.
Acha, if you want, we can have this matter at 2.
Yes, my lord.
Maybe you can explain to them
Yes, my lord.
that this is the simple order.
Yes, my
Either you acquire or you vacate, once the verification
Yes,
has
my
been
lord.
done. Now, unless they give us something concrete by 2 o'clock,
Yes, my lord. If I may tomorrow,
tomorrow is a DB,
day after tomorrow.
day after tomorrow, Thursday. Okay. Should we record anything in the order, or will you be able to convey it to them?
I may be convinced them.
You will convey. But day after tomorrow, we will not take this answer from them.
Yes.
Okay. At the request of Ms. So-and-so Learned Counsel, you are appearing for respondent number?
3, 7, and 9.
Have you filed your wakalatnama in these matters?
Yes, my lord.
Okay. Learned Counsel appearing for the respondent number 3, 7, and 9 has prayed that this matter be taken up on Thursday, since she has received instructions today in the court premises itself. Full stop. She would also like to get some further clarifications on the instructions to the queries made by this court during the consideration of the matter. Full stop. Accordingly, list the matters on Friday or Friday?
Deeply obliged.
Thursday? Thursday. Make it Thursday. Yes.
Obliged.
13th.
Your Lordship, similar order may be passed up to item number 15.
15.
Whether she has any instructions on them? No.
Similar.
From 1 to 15.
Yes,
From,
my lord.
1 to 15.
1 to 15.
Item 16.
Yes, who appears in 16? Yes, what is the order? This is also contempt, no?
Not contempt, my lord. This is regarding my SBI account was freezed by the SBI account.
Yes.
My lord,
Yes, just a minute. Just a minute. Where is the writ petition? This is additional affidavit. Rejoinder. Okay. No. Oh, yes, 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 yes. Yes, what has happened, madam? Where is it? We are taking it for disposal. Both parties prepared? All parties represented? All parties are represented?
Yes, my lord.
Yes. Yes, madam, what is it? Tell us.
My case is compensation was credited to my land was secured for widening of NH 302. Then after a year, the SBIO SBI had freezed my account.
Okay.
SBI account. That is on 22nd May 2023. My account was frozen on 22nd May 2023 due to the direction of Kala. Then this matter was informed to me on 23rd/6/2023. It is in page 32 of my petition.
Page 32.
Of my petition.
Yes.
They informed me that my account had been freezed due to the direction given by the Kala.
Okay, then.
Because of that, I am filing this writ petition to unfreeze my account.
Okay. Now, their stand is that money was given wrongly to your account.
They say that.
Huh.
But my land was secured. It can be seen, it is in page 19.
Oh.
Page 14 of my petition is the notification under 3D. Page 14 of my petition. Then my name is reflected in survey number 185, it is in page 19. Page 19,
185.
serial number survey number 185.
Let's see, 185, yes. So how do we find
Then-
out how much amount you were supposed to receive?
The amount, as per the assessment record, the amount which we had received is, the total is rupees
What is your name?
37 lakhs.
Yes.
17,672. It is in page 28, and the type copy is in page 28 there.
Now, where do we find the amount which was required to be deposited to your account? There must have been some award that this is the amount you are supposed to get.
Yes, my lord.
Where do we find that, madam?
Where's the transition? It is in page 31.
Page
31 of my petition.
No, that 31 is the deposit already made to your account.
Yes, my lord.
What is the amount that you were actually entitled to receive under
It is
the
the whole
award?
amount. It is the whole amount because the assessment, it is in page 22 of my petition.
that is what I was asking
This is the assessment report which the Kala had taken from my land.
Page 22 onwards.
Yes, 22.
Where do we find the amount? That this is the amount you are entitled to. Somewhere that amount has to be shown to us.
These are page 22 to 24 are the assessment report which the Kala had taken.
3,14,200. Is it at page 25A? Is that the amount?
25A,
Serial number 185?
not only 25A,
Which is the amount you are supposed to receive, madam?
my amount which I supposed to be received is as per the TG report, it is in page 31.
Now, page 31.
Survey number 185.
Oh yes, estimate. 37,000, 37 lakh,
Yes.
17,672.
Yes.
Okay, and what did you receive? Okay. So now their stand is that you received some additional amount and therefore they had to freeze your account. What is the excess amount that they are saying you received?
No, the whole amount was deposited into my account. Then after some days, Kala sent correspondence letter to SBI. It is in page.
So
33. Then they say that wherein is that the amount which we had deposited should be apportioned between Pillar Thamwan and Tourism Department. Because of that, they freeze my account.
So now, what do you say? Should the amount be apportioned between you and the tourism department or not?
No.
No.
Because in this respect, this Honorable High Court had given opportunity to file additional affidavit to Kala. Additional affidavit
Yes.
to Kala, and if we go through the additional affidavit, it is in page 3. It is in page 3, para number 6. May I read out, my lord?
Yes, this Department of Tourism, have they filed any affidavit? Are they party
My
here?
Lord, that I would like to interfere. Your Lordship, can you hear me, please?
Yes.
I am appearing for Tourism Department. Actually, my Lord, when this petition was filed, Tourism Department was not included. The petitioner at their own, I don't know, their risk, they have not included us because we are the aggrieved, the main aggrieved. So we filed this thing IA for impleadment. We are included, my Lord. So, my Lord, at this time, as it is very clear, the main aggrieved is Tourism Department. So allow us to file counter affidavit. So everything will be.
Have you filed your affidavit? No.
My Lord, we have not filed.
Okay. Now, do you have any instructions from the department as to what
I
is
have
the?
instruction. I have
Wait.
received
Listen
some
to me.
documents.
Listen to me. Let me complete. Do you have any instructions from the tourism department as to what is the amount being claimed by the department?
My Lord, that I have to.
What is their claim?
I have to see. Right now, because I have given only
Because
some.
if the amount is supposed to be apportioned between the petitioner and the department,
Yes.
then whatever is the amount that the tourism department is claiming,
Yes.
keeping that aside, if the other part of the award is the claim, is the entitlement of the petitioner for the time being, prima facie, her account cannot be kept frozen for the whole amount. It can be only kept frozen for an amount which the tourism department is entitled to claim back.
Your Lordship,
And that has to be done by due process of law. It cannot be simply, I need this money, so give it to me.
My Lord,
Yes.
At this time, I would pray that counter affidavit may kindly be.
When were
filed.
you impleaded? When were you impleaded? That impleadment petition, I can dekho to.
Lordship,
Ah.
let me finish my submission. Then after that they have opportunity to say whatever they want.
We'll come back to you. We are just trying to find out.
Yes.
Let me understand the case, then maybe I can.
It is in order 1/7/2024. Then the
1/7/2024.
1/7/20.
What is that order? There is already an order of 22/3/2024 allowing you to operate the account. So you are now operating the account?
Yes, we are operating the account.
Okay.
And the remaining balance also we already taken out.
All of
Yes,
it, the whole
yes.
amount you have taken away?
Yes.
But it is there also in the record that adverse orders in the proceeding, you will be allowed to, you will be required to refund the whole of it. You are respondent number, tourism is respondent number, impleaded as respondent number?
6.
6. You were impleaded when? Then the hurry should be on the part of the respondents where the petitioner is hurrying, if you have taken out all the money. You are Mr. Pautu?
No, that's my junior.
Huh?
My junior. I'm Jesse.
Who is the intervener?
My lord, tourism department.
Intervener?
Yes.
Okay, Mr. Pautu appeared on that particular day. 17/11/2024. For 1 year has passed, you have not filed your counter affidavit.
My lord, actually, that IA was an additional affidavit was directed to be filed.
By?
Then we are never given chance to file counter affidavit. So then, because we are relying the affidavit filed by the government as of now, but now some new things have come up. So circumstances, because of some new circumstances, we need to file counter affidavit.
You are, who is respondent number 4? This
Your
is,
Lordship, it's Kala.
Kala has filed the affidavit.
Yes, as well as the additional affidavit as directed by the
So
court.
now, respondent number 6 wants to file the affidavit in opposition.
Yes, Your Lordship. If you
How
allow-
much time do you require?
My lord, 2 weeks.
2 weeks. Okay, we'll hear you then. Yes, just a minute. Yes, madam, you were saying what?
Then I'll continue my submission. When we had gone through the additional affidavit filed by the Kala,
Yes,
then in para number 6,
yes.
may I read out, my lord? That it is respectfully submitted that the Tourism Department Government of Mizoram had bought a portion of land of the petitioner covered under Pirdi Pata for consideration amount of rupees 10 lakh without formal sale deed as mandated. How can they purchase my land without formal sale deed? In support to my submission, I have two case law.
So, you are appealing for the Kala. Now, when there is a transaction, alleged transaction for a piece of land, immovable property, can you still say that sale can be taken into account? Who is given this? Who has given this judgment?
Myself.
Acha.
Then may I continue, my lord?
Yes, please.
Kolkata Municipal Corporation and another versus Bimal Kumar Shah. In this case law, starting from para 24 to para 31, it is mentioned that there are 7 principles which are integral for the state and central government to be followed for concerning the compensation. They have to follow this mandated provision. 7 principles for occupied and occupied the private land. They cannot take private land without due procedure.
But that has already been acquired. Now,
No, it is not acquired. The additional affidavit clearly stated that without formal sale deed, they have to publish and notice for land acquisition upon my land.
No, your entire land has been acquired. You have been paid the compensation for that.
No, that is another case. That is for widening of NH 302. And what we are saying is, in my land, the tourism department had illegally and unlawfully constructing the tourism department.
Is that a case we can take up in the writ petition? We have to confine ourselves to the prayer made in the writ petition that your account has been frozen without following the process of law.
Yes, my lord. That is my prayer.
But we will not say whether the tourism department has any right to recover from you, whether the government should pay the tourism department or should pay you, why should we go into that?
Yes, my lord. My prayer is to unfreeze my account only. Then
Any authority, the Kala has to reclaim. Yes, respondents, what do you say? Madam, what do you say?
It is true that their main contention, the prayer, was to defreeze their account. But then we go into the details because it is true that there is no registered sale deed. However, in the year 2017, the tourism department have constructed the building on the land of the petitioners and they have paid 10 lakhs.
Well, how?
10 lakhs, which is already
For what?
accepted
For what?
for the land.
How do we know that? From what document do we know that if there is no sale deed?
It is already submitted before your...
And for the purposes of a writ jurisdiction, madam, we are asking you this, only for
Yes.
the purposes of the writ
For the
jurisdiction.
Yes.
Can this court decide who has the right over what?
No,
We
Your
can
Lordship,
only say-
that is the question of facts which has to be dealt in the trial court.
Right. So any claim that the tourism department has
Yes. it's-
against the petitioner
Yes.
or any claim it has over the award, it has to be done either before the
It-
person who gave the award,
Yes.
everything to the petitioner, or it has to be done in a civil suit saying that, okay, I had built my building there, so I should be compensated for the building and all. Writ court will not enter into that. So, prima facie, we feel that the accounts have to be allowed to be operated.
It's already operated.
And since already there is an undertaking before this court that any amount which may be due to the tourism will be refunded by her, and that is the reason why the account was allowed to
Yes.
be operated. If the tourism department can, by a court of law, bring about an order saying that they are entitled to some amount of it, the recovery is already provided for in the interim order
in
of
the
this court.
interim order, yes.
And therefore, the tourism department has to take recourse to,
Correct, yes.
otherwise,
It's about 14 lakhs.
one person cannot, you cannot freeze the account or not allow a person to use the money which he is not a part of. He was not part of the, he did not make any representation to anyone. Assessment was made by the authorities concerned.
Dollar, yes.
Award was given in his favor.
That was a condition in the...
So,
Yes, okay.
but then if you don't allow the tourism department to have their affidavit on record, yes, take down. Heard Ms. So-and-so learned counsel is paying for the petitioner. Also heard so-and-so learned counsel is paying for the
Respondent number 4.
respondents. All the respondents you can take down. Mr. So-and-so appearing for the respondent number 6, comma, newly impleted by...
Respondent number 5.
Respondent number 5, comma, impleted by order dated so-and-so. Just a minute. Now, who was, Mr. So-and-so, the council appearing for the respondent number 5 has submitted that he would like to file an affidavit in response to the contentions raised in the writ petition, full stop. It is seen that by an interim order of this court, the petitioner was allowed to operate the bank account via savings bank account number 330167625571, subject to furnishing an undertaking before the bank that in the event any adverse orders are passed in this proceeding, comma, the petitioner would be required to refund the amount as may be decided by the court, and the respondent number 4 would also be entitled to recover the same by due process of law. Full stop. Ms. So-and-so under counsel appearing for the petitioner has drawn our attention to the additional affidavit filed by the respondent number 4, wherein it has been stated that where is that affidavit? Where is that affidavit? I was just reading. wherein it has been stated that the Tourism Department, Government of Mizoram had bought a portion of land of the petitioner covered under patta number so-and-so for a consideration under patta number 738 of 1976 for a consideration amount of rupees 10 lakhs without formal sale deed as mandated. Full stop. On the said land, RCC building a tourist lodge, TLA-BUNG, Klabang, was constructed by the department, which was completed in the year 2017. It is further stated in the affidavit that partition and mutation of the land so bought, BOUGST, bought by the department was not completed in the year 2021 when notification for acquisition of the affected land was notified on 22/11/2021. It is not known as to whether till date the partition and mutation of the land so bought by the department has been recorded in the revenue records. Full stop. The prayer in the writ petition, next paragraph. The prayer in the writ petition was to allow the petitioner to unfreeze the personal saving bank's account held by her in the with the State Bank of India in its Klabung branch in Lunglei district. Full stop. By an interim order, on the basis of the interim order, the petitioner is operating the aforesaid bank account. Full stop. The Tourism Department, next paragraph. The respondent number 5 is given an opportunity of 2 weeks to file their affidavit in response to the writ petition. It is made clear that in the absence of the affidavit in opposition, on the next date fixed, the matter will be taken up for consideration and disposal. Full stop. List the matter after 2 weeks on a date to be fixed by the registry. Yes, sir, you file your affidavit because any claim that you might have to the any portion of the award, if the writ court is not inclined to go into it because it will require factual determination, disputes, I don't think the writ court can go into that.
That's true, exactly true.
So any claim you need to make on that amount, it has to be on the basis of documents and records.
Yes.
The Kala has said there is no record. So, we'll decide it on the next date. Yes.
Yes, Lordship. Not so obliged, Lordship.
Item 17.
Yes. Yes.
Lordship, the grievance of the petitioners, 3 number, is that their lands have been encroached upon by the railways, respondents number 1 and 5, during construction of the new railway line, in spite of the fact that their lands have not been acquired for the railways project. The petitioners had submitted complaints to the DC, and accordingly the DC had conducted spot verification on 2 occasions. And on both occasions, it was concluded that the land has been encroached upon.
It was?
There was a finding that the lands have been encroached upon. But the railways say that these lands fall within the right of way, ROW, which means that the land has already been acquired. So they have, the petitioners have no right to claim the land.
No, the railways had a certain portion of land on which they could do their constructions, whatever was required.
Yes.
Your land does not fall within that area,
No, yeah,
but railways says that since it is on the right of way, therefore we have gone into their land also.
Right of way is the land which was acquired by the railways. So they're saying that since this land has already been acquired by us. But our stand is that this land has never been acquired by them. It is not included in the award also. It is not included in the premium notifications also. So, but in spite of that, they started encroaching upon our land. So we submitted complaints to the DC. DC held joint spot verification in the presence of all parties. And there was a finding that, yes, our lands have been encroached upon.
Where is that report?
If I may take your lordship to page 44. Page 44, your lordship, annexure 9. This is the report submitted by the SDC to the Deputy Commissioner at para number 2. Para number 2, this lady, Dim Ngai Wui, is petitioner number 2. In page 44, this is the report submitted by the subdivisional SDC /
Aizol.
Yes. Your Lordship, the detailment order is at page 42.
Page 42.
Annexure 8 is the detailment order. This is the detailment order. And serial number 1, P. Jennifer Vanal Troy Pachau, is detailed to conduct the verification. And
You are at serial number 9 at page 43?
at page 43, I am at serial number 9. Petition number 2. Petitioner number 1 and 2 are the son and daughter of the petitioner number 2.
No, where do we find your names?
Your Lordship, if your Lordship will see, we have
Is it serial number 9 of page 43?
Yes, the 3 house passes. There are 3 house passes. House pass number 335. House pass number 335 is in the name of petitioner number 1. 336 is in the name of petitioner number 2. And 338 is in the name of petitioner number 3.
So here the railway complaint list says damaged crops and land beyond acquired area.
Yes.
An area of Imanov was acquired under house pass number 337.
Yes.
She requested to verify her lands.
So out of the, we had a number of passes, only 337 was acquired.
Acquired and 33?
335, 336 and 338 were not acquired.
Okay, now this page 44 says
Para
that reassessment
Yes.
may be necessary for mutation of the acquired area from the non-acquired area. What happened thereafter?
Thereafter, Your Lordship, the page 47, the Deputy Commissioner passed a detailment order again at page 47. In pursuance of verification report submitted by the sub-divisional officer of this office, the following officials are hereby detailed to conduct assessment, survey and measurement of encroached area. So this was again a detailment order made by the DC. And as per this, at page 48,
48 years.
as per this detailment order, Your Lordship, again verification was conducted. And the information, the result is at page 49. During verification, a copy of land plan was produced by the representatives from NF Railways. In light of the document produced, it appears that the site described by the landowner as their land was demarcated under ROW and acquired by NF Railways. The landowner, however, stated that no compensation was paid to them. Copy of the land pass, it was stated, was already submitted to DC Aizol. Suggestion: the Office of Deputy Commissioner Aizol may seek information on the ownership of land from the area claim from Land Revenue and Settlement Department. So, Your Worship, the claim of the railways is that the land has been acquired, it falls within the right-of-way, ROW. But the fact remains that our lands have not been included.
But
in,
unless it is demarcated, can we take a call?
yeah, that is why, Your Worship, if Your Lordship will see in the affidavit filed by the railways,
They are saying it's right of way.
yeah, they are saying that unless the the land is demarcated. So, Your Worship, direction may kindly be given for demarcation of the land.
Who appears for the
Your
office
Lordship,
of the
I'm
Deputy
appearing
Commissioner?
for the state respondent.
Yes. Why
Yes,
do you
Your
not
Lordship.
demarcate it?
Your Lordship, if I may be given at least 2 weeks' time to get instructions.
Your Lordship, they have
Because-
already submitted that they're not going to file any affidavit.
That is what I was noticing that order.
Yes, Your Lordship. This matter was handled earlier by Mrs. Carolyn. She's on maternity leave, so I'm appearing on her behalf. And if this is a new development that is requiring our action, Your Lordship, if I may be at least granted 2 weeks' time.
Your Lordship, if my humble submission, Your Lordship, let it come up next week. Yeah, she can make one phone call and they just have to demarcate the area which has been acquired.
You see on 9/6/2025,
Yes, Your Lordship.
no further time would be allowed. State respondents are allowed to file their affidavit within 3 weeks. Then 4 weeks was again granted to you.
Yes, Your Lordship. The council was, she is already on maternity leave, Your Lordship, in the month of August itself.
Or maybe because no affidavit was filed, okay.
Your Lordship, a simple direction to demarcate the lands. I think it will not prejudice anyone.
You have your instructions by Thursday next,
Yes, Your Lordship.
around 9 days' time.
Yes, Your Lordship.
Have your instructions
Yes, Your Lordship.
if the demarcation can be carried out.
Understood.
Because you know which part of the land is acquired, which is not. If their land have already been included in the ROW, nothing remains.
Yes, Your Lordship.
If their land has not been demarcated, then further orders will follow. Take down heard Mr. A.R. Malhotra, Learned Counsel, appearing for the petitioner. Also heard so and so for the respondents. By the, and it has been recorded in the order dated 22/9/2025 that the learned government advocate submitted that they would not be filing any affidavit in the matter, full stop. The learned, respondent number 1 to 5 have submitted their affidavit in opposition, full stop.
1 and 5.
1 and 5.
1 and 5.
Sorry, 1 and 5 have submitted their affidavit in opposition on 22nd of September 2025. As per the said affidavit in opposition, the respondent number 1 and 5 contend that the land involved in this litigation is included in the right of way and has been included in the draft award, pursuant to which payments have also been made, full stop. They thus deny any encroachment upon the petitioner's land, full stop. Mr. A.R. Malhotra, Learned Counsel, appearing for the petitioner, has drawn our attention to the verification report submitted by the SDC/BDO to the Deputy Commissioner, Aizawl, wherein it has been suggested that the office of the Deputy Commissioner Aizawl may seek information on the ownership of the land from the area claimed from LR&S Department Aizawl, full stop. Mr. Malhotra has submitted that a demarcation process, if carried out by the state respondents, if a demarcation process is carried out by the state respondents, it would help in the adjudication of this matter, since it can be traced out, it can be then traced out whether the land of the petitioners were in fact included in the award, in the acquisition process, and whether the railways are acting within their right of way, full stop. Ms. Sensol and council appearing for the state has submitted that she would have her instructions by, what is the date?
20th.
20th of, by 20th of November 2025, full stop. Accordingly, list this matter again on 20th of November 2025, by which time the respondent number, the state respondents may either file their affidavit in response to the petition or supply necessary instructions to the council appearing on their behalf regarding the demarcation of the land which was acquired, full stop. List accordingly, yes.
Item 18.
Lordship, this is content matter. Judgment and order passed by this Honorable Court. Operative portion is page 25.
Page?
25. Lordship got it?
Page 25, yes.
Your hearing. Upon due consideration of the matter in its entirety, the following directions are made. The Act of 2018 does not contemplate deduction of cess from the compensation to be received by the landowners, and therefore deduction of cess made from the amount to be received by the petitioner is only illegal. Hence, the amount so deducted should be refunded to them within a period of 2 months from the date of receipt of a certified copy of this order. This one is already complied, Your Lordship. And number
The
2,
refund has been done.
done.
Okay.
Number 2, the district collector concerned shall determine the date of taking over possession of the land of the petitioners after giving them due opportunity of hearing along with the BRTF authorities within the period of 2 months. Upon such determination, the collector shall assess the amount of interest payable to the petitioners and forward the same to the respondent, Union of India, respondent number 1 and 2, who shall, upon receipt of the same within a period of 2 months, deposit the amount so assessed before the collector for disbursement to the landowners. On the part of the district collector, it's complied and forwarded. Kindly see page 32, Lordship, Annex 5. Forwarded the calculated interest payable in January 21st. So it's already past 10 months. So being achieved, we have filed. And number 3, page 25, direction number 3.
Page 25.
Yeah, direction number 3.
To establish that
Yeah, to
land
establish
acquisition,
the reference
yes.
court. This is not done. So, on the part of the district collector, he has done his part. And with regard to the interest payable by the respondent number herein 1 and 2 is not yet complied, and respondent number 3 has to establish the reference court. This is not yet done. So being aggrieved, we have filed this petition, contempt petition. So at this stage, Your Lordship, if you kindly permit to direct the respondent number 1 and 2.
Why? Respondent number 1, where is the service report?
Yeah, they have already represented.
I'm for
Respondent number?
1 and 2.
1 and 2.
I just filed my power for respondent number 1 and 2.
And
My Lord,
We
then
have
I
it
may
on-
be given some more time to obtain instruction in this
No,
regard.
I have got the, you have filed your power for the respondent number
1 and 2.
1. Sorry, respondent number
1
2.
and 2.
There is no 2, no 1. Where is that for 1? You have not filed your power for 1.
So they may take instruction, this may be fixed, listed again on Friday. In the meantime, sit and
Yes,
fix.
madam. For 1, where is it?
My Lord, if-
When did you file it for 1?
my Lord, I may, if I may permit it, my Lord, I may be check it again. then
Because see, this is contempt matter.
yes, my
You
lord.
would say you appear, we proceed on that. Something adverse happens, you will not have a wakalatnama on record, there will be a big issue.
Yes, my lord. I'll check it, my lord.
Huh?
Your Lordship.
And respondent number 2, when did you file it? 6th of August 2025. Have they given you any instructions on that? No. When did you file it? It was July. And they are not giving you any instructions on that?
Yes, my lord.
No instructions.
Because since new engineer has come, my lord. something-
This man is not there anymore.
Yes,
This Girish Prasad is not there.
my lord.
Is Mr. Girish Prasad Singh still there?
Is transfer out, my lord.
Your Lordship, if I may, on behalf of the state respondents, that is 3 and 5, DC is already complied. So 3 and 5 regarding the appointment of a authority under the Reflectly 2013 Act, I have a letter which is dated 16th October from the registrar of the principal bench, wherein the proposal for designating the existing district and session judge and additional district and session judge as presiding officers as per the section 53 of chapter 8 under the Reflectly 2013 Act has been considered and approved from the principal bench, Your Lordship.
Okay, so now at least that means some process has been done with regard to direction number 3.
Yes,
Some process has been done.
we are happy with it.
Now, respondent number 1 and 2, one has not filed his affidavit, nor his power.
And if they are already complied, only respondent number 1 and 2 are not complied.
That is what. Yes, madam, we shall have this respondent number 2 in this court on the next date, if he does not give you any instruction.
My lord, now the respondent number 2 is transferred out. Then, if I may be given some more time for obtaining instruction from the new incumbent, my lord.
But the new incumbent is not a party here.
Yes, not a party now.
And we have to know what the old respondent did. The earlier respondent, what did he do? Did he sleep over the matter? Did he take some interest, write some letters? Is it not? This is contempt, not writ.
My lord, if I may grant it 2 weeks' time, then in the meantime, I may make an arrangement for this.
Yes, take down, heard Ms. So-and-so, and counsel appearing for the petitioner also heard Ms. So-and-so. Learned counsel appearing for the respondent number 2, and you are appearing for 3, 5 and 6.
3, 4 and 5, Your Lordship.
Huh? There is no memorandum of appearance for 4.
My lord, I'm appearing for the respondents 5 and 6.
5 and 6, yes. What is your stand?
It's nothing to do with them, Your Lordship. There is no direction upon them.
Upon 5 and 6?
Yes.
Okay.
And Your Lordship, if I may, there is supposed to be another respondent number 7 who is supposed to be impleaded. Mr. Vanil Moya is the current. Yes. Your Lordship, if I may be allowed to file a wakalatnama on behalf of respondent number 7.
7?
Yes.
Where is he? There
He's
is
a
no
newly
order.
impleaded, Your Lordship.
Where? Where is the new?
He's the current secretary, Your Lordship.
Has he been impleaded, madam?
Not yet, Your Lordship. You
Then
have
there is no
idea.
application to implead him. Why should you bring
He
him
has
in
not
forcefully?
yet impleaded.
Why should you bring him in forcefully? Petitioner does not want him to be a party. What can we do?
You have no idea, it's already changed. You have come to know now only that they have changed. So anyway, they have complied so far as the submission made by the government advocate.
The learned counsel appearing for the respondent number 2 has submitted that. The respondent number 2 has since demitted the office of, he was holding what? Demitted the office of the chief engineer, BRTF, project Pushpak on transfer. And as such, she is unable to procure updated instructions with regard to the compliance of the orders passed by this court. Full stop. It is made clear that the respondent number 2 is required to file his response to the notices issued stating the steps taken by him for compliance of the order of this court, if any. Steps, if any, taken by him for compliance of the orders of this court, full stop. It is further made clear that in the absence of a response on the part of the respondent number 2, on the next date of listing, comma, appropriate orders would be passed. Appropriate orders may be passed. Full stop. List this matter after 2 weeks on a date to be fixed by the registry, allowing the respondent number 2 to bring on record the response to the allegations leveled in the contempt petition. Full stop. You have 2 weeks' time to do that.
Yes, my lord.
But he has to answer because he was there, he has to tell us what he did during his office time.
Yes, my lord.
And
In the meantime, Your Lordship, if required, I may be allowed to implead the new incumbent also.
why should we allow anything before an application is filed? File the application, we'll see what is to be
Yes.
allowed. Because unless you tell those new
I know.
incumbents, this is the order, comply.
I know. Yes, we'll do that, Your Lordship.
Item
Improvement
19.
will not be allowed. Yes. This is item number 19. How many items are there?
Your Lordship, I am for the petitioner.
Yes.
And my lord, we received written objection. So my lord, there's a circumstance that we need to file rejoinder. My lord, actually in this petition.
What
so
is the order which you are complaining, non-compliance?
My lord, it's at Annexure 4. Judgment is at Annexure 3. Page number 12.
Page number
12.
12.
Yes. Because the written objection I received from my junior, and there's some.
You were required to dispose of the appeal.
Yes.
But their affidavit is not on record. No one is appearing for, anyone appearing for the sole respondent?
My lord, I'm appearing for the sole respondent.
Have you filed your affidavit?
Yes, my lord.
It has, where is that affidavit? This one at the top.
That one I
Yes,
did
sir.
not
Who
read.
is the appellate authority, actual appellate authority? Who is the appellate authority? They are saying the respondent number 1 is not the appellate authority.
That's why, my lord, there's some.
My lord, the appeal committee is the appellate authority, not the disciplinary committee who has passed the order. And also, my lord, as per this Article 120 of the AIFF Code, an appeal fee has to be paid, which the petitioner have not paid yet. An intimation was sent to the football club as well as individuals.
See, this judgment, this order which you had to comply with, it says,
My lord, the operative portion is at page 21 of the contempt petition. If I may read.
just a minute. Why don't you, yes, what were you saying? Yes, madam?
My lord, the operative part of the writ
So
petition
before we go
is at
further,
page
my lord-
21.
lord,
The
may I
appellate
please-
authority shall consider the said appeal in terms of the AIFF Code, All India Football Federation, AIFF Disciplinary Code 2024, while ensuring that the principles of equity and fairness is duly upheld. That, my lord, if in our show cause reply, we had extracted Article 120, which is at page 7.
My lord, may I please
Appeal
interfere?
fee.
Please.
All appeals shall be accompanied by an appeal fee of 60,000 in case of an individual appellant, 1.2 lakhs in the case of a club member association, not being a natural person.
Okay.
The appeal fee shall be transmitted to the nominated AIFF account before the expiry of the time limit for submitting the appeal brief. If, my lord, if this
No, you tell us who is
120.2...
the appellate authority first. Who is the appellate authority?
The appellate authority is the committee, the appeal committee.
That appeal committee is within the MFA.
Yes, the MFA will have to set it up. The appeal committee is already set up, but for the appeal to be heard, the petitioner has to pay the appeal fee. That, my lord, the AIFF code has clearly specified in Article 120.2 that...
So your
if-
stand is that he has not paid
Yes,
the,
my lord.
and this All India Football Federation disciplinary code that itself provides for payment of the fees.
Yes, that...
And he has not paid the fees.
He has not paid the
Okay.
fees.
Yes,
And
take down.
intimation was already sent to the petitioner individually and as of club.
Okay.
But still, as of today, they have not paid. So the appeal could not be heard.
Okay. Take down. Heard Mr. So-and-so learned counsel is paying for the petitioner. Full stop. Also heard Ms. So-and-so learned counsel is paying for the sole respondent. No. For the sole respondent. Who submits that an affidavit in response to the allegations made in the writ petition has been filed on the 4th day of November 2025 and is on record, full stop. Having gone through the affidavit filed by the sole respondent, it transpires that the consideration of the appeal as required by the orders of this court is to be done in accordance with the AIFF disciplinary code, full stop. Ms. So-and-so and a counsel is paying for the sole respondent has submitted that the said disciplinary code requires depositing of a fee of depositing a fee for appeals filed by individual and a different fee for appeals filed by a club, full stop. Ms. So-and-so has submitted that the writ petitioners / applicants in this contempt petition have been intimated about the requirement of the deposit of the fee, however, no such fee has been deposited till date, for which the appeal, what is that committee?
Appeal committee.
The appeal committee has not been set up and the appeal has not
My
been...
lord, the appeal was already set up. However, their appeal is not admitted yet.
Sorry, then you take it down like this. However, the said fee has not been received and therefore the directions regarding the disposal of the appeal could not be complied with till date, full stop. It is submitted that the inability to proceed with the appeal is only because of the non-compliance by the applicants regarding the fees to be deposited, full stop. Situated thus, Mr. So-and-so, and counsel is paying for the petitioner has sought for some time to respond to the contentions.
To file
raised
rejoinder,
in the-
Your Lordship.
Sorry?
Rejoinder to the affidavit filed by the respondent. Rejoinder.
To respond to the affidavit filed by the sole respondent by filing a rejoinder, full stop. Accordingly, he is allowed, how much time?
2 weeks' time, Lordship.
2 weeks' time to file the rejoinder affidavit, full stop. List the matter after a week of filing of the rejoinder affidavit by the petitioners on a date to be fixed by the registry for further consideration. Yes.
Oblige.
Obliged.
For orders, item 20.
Yeah, please, Your Lordship.
Yes.
My Lordship, this is a condonation application, my Lord.
This was
Filed
there
under-
yesterday.
Yes, my Lord.
74 days delay.
79, my.
79 days delay, yes.
Yes, my Lord. My Lord, this is filed under Section 5 of the Limitation Act.
Why the delay?
My Lord, if I may take you to page 3 of my IA, my Lord. If I may read out from para 2, my Lord. Your Lordship has it, my Lord. That the limitation period within which the application has to file an appeal has already lapsed. In other words, the last date of filing an appeal within the stipulated period is 9 March 2025, and the period of delay may also be counted from 10/3/2025. Hence, there is an unintentional delay of 79 days in preferring the appeal, my Lord. My Lord, that it may be fairly to submit that the delay in filing the appeal against the impugned judgment and order dated 30th November 2024 and decree dated 9th December 2024 is due to bona fide reason and circumstances beyond the control of the applicant. Hence, the reason for the delay may be explained hereunder. That the applicant first came to know about the impugned judgment and order dated 30th 11 2024 and decree dated 9/12/2024 after the same has been furnished to her by the previous counsel in the trial court only on 21st February 2025. That is after 74 days of the pronouncement of the impugned judgment and order. That as soon as the applicant came to know about the impugned judgment order dated so-and-so and decree dated so-and-so, the applicant approached her counsel in the trial court on 24th December 2025 and urged him to appraise her about the contents and reasoning given in the said judgment and order and decree. That thereafter, the applicant was informed by his previous counsel in the trial court on 26th 2nd 2025 that if she is aggrieved by the impugned judgment and order dated so-and-so and decree dated so-and-so, she would have to file an appeal before the High Court, and certified copy of judgment and order was also applied that time and got same on 27th 2nd 2025. That the applicant being highly aggrieved and dissatisfied with the impugned judgment and order dated 30th 11 2025 and decree dated so-and-so, my Lord, she approached the counsel in her locality and the matter was under consideration by such counsel till 15th March 2025. That as the counsel in her locality advised the applicant to approach counsel in Aizawl, the applicant being a housewife who is taking care of her infant baby could not go to Aizawl for a week, and she approached another lawyer in Aizawl on 31st 3rd 2025 and approached one lawyer who examined the case for 3 weeks. However, as he declined the engagement, the brief is again handing over to the present counsel on 21st 4 2025. However, the leading counsel was traveling to Guwahati for professional assignment in between 24th to 27th April, which delayed the drafting process, and thereafter drafting was finalized and ready to file in this first week of May 2025. That as a result, there is unintentional delay of 79 days, and as such, reasons are bona fide and unintentional. That the applicant humbly states and submits that the reason for the delay are bona fide and unintentional. In other words, the applicant is not negligent in pursuing the case. Therefore, it is humbly submitted that unless the delay is condoned by this honorable court, the applicant would suffer irreparable loss and hardships. In fact, the very purpose of filing the appeal would be rendered futile, and there would be miscarriage of justice as the applicant has good ground in the appeal. My Lord, to support my submission, I would like to I would like to refer to this citation, 2013, Volume 12, SCC 649.
So, in the title suit, you were the?
In the declaratory suit, my Lord.
Huh? In the declaratory suit, you were what?
The plaintiff.
You were the plaintiff. The
Yes, my
suit
Lord.
was dismissed.
The suit was dismissed.
Dismissed. Okay. Yes.
The suit was dismissed My lord, the relevant page is at 658, my lord. Isha Bhattacharjee versus Managing Committee of Raghunath Pur Nafar Academy and others. My lord, the relevant, this is at page 658, my lord.
Page?
658.
Yes.
My lord, the relevant paragraph is from 21.1. My lord, this is the principles applicable to an application for coordination of delay. My lord, if I may read out.
658. 658, which one?
658, para number 21.1. My lord, if I may read out, just 3 relevant points, my lord. I will not be reading throughout, my lord. If I may read out. There should be a liberal, pragmatic, justice-oriented, non-pedantic approach while dealing with an application for condonation of delay, for the courts are not supposed to legalize injustice, but are obliged to remove injustice. 21.2, my lord. The term sufficient cause should be understood in their proper spirit, philosophy, and purpose, regard being had to the fact that these terms are basically elastic and are to be applied in proper perspective to the obtaining fact situation. 21.3 point, my lord. Substantial justice being paramount and pivotal, the technical consideration should not be given undue and uncalled for emphasis. My lord, the most important consideration is substantial justice. Technical or procedure details should not get in the way if it means denying justice, and also when substantial justice and technical consideration are pitted against each other. The case of the cause of substantial justice deserves to be preferred, my lord. And my lord, there is another citation which I would like to rely on is 1987, volume 2, SCC 107. Collector Land Acquisition, Anantnang and another versus MST Katiji and others.
Anantnag, yes.
Yes, my lord. The relevant point is at page is at 108. Point number 3, my lord. The first paragraph. If I may read out, my lord.
Yes.
The legislature has conferred the power to condone delay by enacting Section 5 of the Indian Limitation Act of 1963 in order to enable the courts to do substantial justice to parties by disposing of matter on merits. The expression sufficient cause employed by the legislature is adequately elastic to enable the courts to apply the law in a meaningful manner which subserves the ends of justice. That being the life purpose for the existence of the institution of courts, it is common knowledge that this court has been making a justifiably liberal approach in matters instituted in this court. But the message does not appear to have percolated down to all the others courts in the hierarchy, and such a liberal approach is adopted on principle as it is realized that, number 1, ordinarily a litigant does not stand to benefit by lodging an appeal late. Number
Okay,
2.
see, read. I read that, yes.
Yes.
Yes, what is the objection?
May it please Lordship. Lordship, I have filed the objection, and I have a strong objection regarding this insufficient explanation of the delay, Lordship. May I take Lordship to the affidavit of person filed by the respondent, number 1, Your Lordship. Relevant is from page number 3, paragraph number 3, Lordship. May I read? That at the outset, the reasons for the delay given in this application could not be termed as sufficient cause to condone the delay. It may not be out of place to mention here that the applicant failed to explain and failed to show sufficient cause for the delay in preferring an appeal. Unfortunately, the applicant's submission lacks any supporting documents which clearly indicates that there is a gross negligence on the part of the applicant in filing this connected appeal, and as such the instant application is defective in law and in fact is liable to be rejected.
You are appearing for the private respondent?
Private respondent, Your Lordship. And learned senior civil judge had passed the judgment and order in my favor, Your Lordship. I am the counterclaimant before the
The
senior
counterclaim
civil
was
judge.
allowed.
Lordship, yes. And I seek Your Lordship kind attention in this regard that this application is not accompanied by any supporting documents, Your Lordship. Though they have so many excuses that was rendered by the applicant, but there is no supporting documents at all, which clearly indicates that there is a gross negligence on the part of the applicant, or there is an inaction on the part of the applicant. And the submission are nothing but a lame excuse in order to cover up the negligence on the part of the applicant, Your Lordship. And may I continue, Lordship? With regards to paragraph number 4, with regards to para number 3A, the answering respondent submits that the impugned judgment and order dated 30/11/2024 and the consequential decree dated 9/12/2024 were admittedly issued
It's
on
okay,
the
we can
same.
read the paragraph, you just tell us the submissions. The paragraphs we'll read, otherwise it will take a long time if you go on reading the paragraphs one by one.
Lordship, here, my
Any
learned
law to-
friend, yes.
Yes.
Yeah, my learned friend had said that they have came to knowledge after 74 days from the pronouncement of the judgment and order and the decree, Lordship. However, in this regard, the judgment and order along with the decree was declared in an open court, which we have the knowledge on the same day itself. And that was not properly explained, Your Lordship. So, and besides that, Your Lordship,
Yes.
then another submission made by my learned friend is that they have approached the 2-3 advocates, and it says that the one advocate may another 2 weeks, another 3 weeks, and also said that the applicant came to Aizawl to approach another advocate, and that was also not any supporting documents. And it is also not mentioned how she traveled to Aizawl by way of private vehicle or bus or sumo. Nothing was mentioned.
Sufficiently not explained,
Your Lordship.
and
Yes. There is
proof
no
of the
supporting
statements not
yes,
given,
there is no
yes.
supporting documents at all, Your Lordship. And
Yes.
the Apex Court had clearly stated that that length of the delay is immaterial, Lordship. It has to have sufficient explanation, and that was lacking of the explanation, and that should not be condoned, Your Lordship.
Okay.
And she had also stated that she has an infant baby, and that also at least it is expected that a birth certificate may be annexed herein, but that also not done by the applicant. So there is an inaction or negligence on the part of the applicant, Your Lordship. At least he has to try to convince this honorable court to show that he has an infant baby. This is the birth certificate, and because of that, he is not able to travel to Aizawl. And that is also not done by the applicant, Your Lordship. So it is not known whether she really has an infant or not. And there are so many, Lordship, unexplained day of delay, Your Lordship, which I have clearly stated in my affidavit, Your Lordship. She stated that she had consulted advocate in her locality. The matter remained for that particular advocates for a number of days, and that is also not explained. And he has to approach the lawyer regarding what has to be done, Lordship. And that was also not done on her part, Lordship.
Yes.
My Lord, in that regard,
No documentary evidence of any
my
of the
Lord, in
things.
that
you-
regard, if I may read out this particular point from my citation, that it is written that every day's delay must be
No, he
explained.
says that that you went to the lawyer, you are not giving a
My
bus
Lord,
ticket,
in
you are
regards
not
to
giving
that,
the.
if it is required, the infant's birth certificate and all those things, I can submit through an affidavit in regards to that, my Lord. My Lord, the applicant has acted with all due diligence, my Lord, in the circumstances. And, my Lord, if I seek your Lordship's indulgence on merit, if I may proceed, to highlight the merits of the case as to why the Honorable Court should allow the appeal to be heard on merit, my Lord. If if I may take you to page from my RFA, main RFA, my lord.
We don't.
Page
How can-
13, my lord. Just 2-3 points, my lord.
Page
13.
30.
Para number 3, my lord. Page 13, para number 3.
30.
1-3, my lord. Page 13. That is the judgment and order, my lord. That is the grounds, I mean. I'm sorry. My lord, if I may read out.
Which one? Which one are you? Don't read out all the grounds. Tell us that this is what the merit is. If you keep reading the pleadings. Sitting here, yes. Yes. Yes, madam, you were saying?
Yes, Your Lordship, I'm representing the states. And I have only one objection regarding the limitation. And
What objection?
For that one, I have only one point, Your Lordship. And regarding the application of limitation submitted by the council, he stated that he had received the judgment and order after 74 days, after the pronouncement of the judgment and order and the decree. And Your Lordship, what I would like to mention here is that actually in that the declaratory suit, the appellant herein is the plaintiff. So it is his duty whether the suit has been decided or not, because he is the one who has to take up the case. And in that regard, merely pointing towards the council, the previous council, cannot be said that that is the justification for his delay without
But
any
then-
documentary proof.
But then on the last occasion, on 4/11, you had submitted that you would not object to.
I was stating that I will not object
Filing to the-
in written. I'm saying that I will do oral objection.
Okay.
My lord, if I may continue with the merits, my lord. At page number 13, my lord.
13 years. Which one were you referring to?
My lord, my grounds.
Yes. Which ground?
Number 3.
Number
3. Roman number 3. My lord, if I may read out.
Okay. Look here, heard Mr. So-and-so, Learned Counsel appearing for the applicant. Also heard so-and-so represents the respondent number 1. You appear for the respondent number 1? And Ms. So-and-so appears for the respondent number 2. This this interlocutory application has been preferred by the applicant, praying for condonation of
79 days.
a delay of 79 days in filing the connected RFA arising out of the judgment and order dated 30/11/2024 and decree dated 9/12/2024 passed by the Learned Civil Judge within bracket Senior Division Kolasip District Mizoram in declaratory suit number 29 of 2021. We have gone through the grounds enumerated in the interlocutory application explaining the delay of 79 days full stop. It has been stated that due to a miscommunication between the previous lawyer, there was some delay in coming to know about the disposal of the declaratory suit filed by the applicant hearing, and further there was some more delay when she had to contact different councils for having the matter filed, prepared for filing of the appeal. Full stop. The Honorable Counsel for the applicant has submitted that there are good grounds for that there are good grounds for interfering with the orders passed in the declaratory suit, which have been enumerated in the connected appeal, and therefore it is prayed that the delay of 79 days may be condoned and the RFA may be taken up for disposal on, for consideration and disposal on merits. Full stop. The respondent number 1 has filed the affidavit in response, in opposition to the interlocutory application, wherein it has been asserted that the applicant has not been able to explain the delay of 79 days and no documentary proof of either having an infant child or of having to travel to different advocates for preparation of the appeal have been annexed to the interlocutory application. Full stop. The Illinois Council appearing for the respondent number 1 has submitted that the applicant has acted in a negligent manner and therefore the delay in the present case does not deserve to be condoned. Ms. So-and-so, yes?
Lordship, I may be allowed to rely upon the coordinate bench of this Honorable Court, the order passed by this Honorable Court, Lordship. This IN number 143 of 2023 is regarding no supporting documents. And then the next one is regarding the grounds taken by the applicant, saying that the negligence of the lawyer, and that also not allowed. And the third one is regarding the length of the delay is immaterial, Lordship. IN number 140 of 2023, operative para is para 7 and 8, Your Lordship.
Yes, Chairman.
IN number 140 of 2023, operative is paragraph 7 and 8, Your Lordship.
This one, this IS Civil 143 of 2023, which part you are relying upon?
This is regarding no supporting documents, Your Lordship.
Where, which paragraph?
Paragraph 7 and 8, Your Lordship. 7 and 8, Lordship.
Paragraph 7 and 8.
Paragraph 7 and 8, Lordship, yes. No specific dates.
Yes, then?
Then, Lordship,
just a minute. Learned Counsel appearing for the respondent number 1 has placed reliance on the order dated 8/4/2025 in IS Civil number 143 of 2023 to contend that in the absence of documentary evidence, the approach of the applicant has to be treated as casual.
Lordship, yes.
And therefore delay in filing the appeal need not be condoned.
Lordship, yes.
He has thereafter referred to
IA number 131 of 2017.
The order dated 10/5/2008 passed in IA number 131 of 2017.
Lordship, yes. Yes, Lordship, yes. Regarding the negligence of the lawyer, start from 7.
Wait.
Start from 7.
To emphasize that
Lordship, operative
in
is
the
a-
absence of any documentary evidence to show that the applicant gave the necessary brief to the council to the applicant to make an appeal, and no dates having been referred to, comma, the application is to be considered as bereft of specifics and is basically a very generalized statement, and therefore the delay in such cases does not deserve to be condoned. He has also referred to the order dated 22/2/2025, passed in IS Civil number 134 of 2024,
Lordship, yes. Operative is from paragraph
to
12.
emphasize that,
Delay is immaterial, Lordship. The number of days regarding length of the delay is immaterial, and proper explanation is mandatory, Lordship.
to emphasize that unless there is a proper explanation to the delay,
Lordship, yes.
comma, the mere length of delay would not be material to take to convince the court to condone delay, full stop. Yes.
And Lordship, last submission is 2013-14 SCC, 2013-14 SCC.
He has also relied upon
2013-14 SCC, page 81. This is regarding what sufficient cause is all about, Your Lordship. The Apex Court says that the sufficient cause means adequate and enough reason which prevented him to approach the court within limitation. So that there is nothing in the application.
Have you taken that down? What he was saying? Taken down? Yes. Where the Honorable, where the Apex Court has held that the sufficient cause should be one which could have prevented the petitioner from approaching the appellate forum within the time frame limited, and any or all causes may not fall within the category of sufficient cause. Yes, full stop. Yes, madam, you want to say something? Learned Counsel appearing for the respondent number 2 has supported the contentions of the made by the Learned Counsel for the respondent number 1, and has submitted that in the absence of any explanation, comma, this interlocutory application does not need further consideration by this court and deserves to be rejected, full stop. In response, the Learned Counsel appearing for the applicant has placed reliance on the judgment of the Apex Court in Collector, comma, Land Acquisition, comma, Anantnag and another versus MST.Katiji and others, comma, reported in 1987 to SCC 107, to submit that the term sufficient cause has been explained by the Apex Court to be adequately elastic to enable the courts to apply the law in a meaningful manner which subserves the end of justice. Full stop. The Apex Court in the particular case had directed a liberal approach to be adopted on principle, and had observed that when substantial justice and technical considerations are pitted against each other, cause of substantial justice deserves to be preferred over the other side. cause of substantial justice deserves to be preferred. Full stop. The learned counsel has submitted that there can be no presumption that delay is occasioned deliberately or on account of culpable negligence or on account of malafide. Full stop. He has submitted that in the present case, the applicant would not have benefited in any manner by causing delay in the matter, since her claim in the declaratory suit was regarding to the rights over a particular piece of land which had been dismissed and rights had been conferred upon the and the counterclaim made by the respondent number 1 as defendant in the declaratory suit had been confirmed by the trial court. Full stop. He has submitted, and he has further submitted that even as per the judgment of the Apex Court in Isha Bhattacharjee versus Managing Committee of Raghunathpur Nafar Academy and others, reported in 2013 12 SCC 649, the Apex Court has reiterated that there should be a liberal, pragmatic and justice-oriented approach when dealing with applications for condonation of delay, that the term sufficient cause should be understood in the proper spirit, since the term is basically elastic and has to be applied in the proper perspective. Full stop. That substantial justice being paramount and pivotal, technical consideration should not be given undue and uncalled for emphasis. The Apex Court had also held that the adherence to strict proof should not affect public justice and cause public mischief, because courts are required to be vigilant so that in the ultimate eventuate there is no real failure of justice. Full stop. The Apex Court had also noticed the distinction between inordinate delay and delay of short duration or few days, and had observed that the second calls for a liberal delineation. Full stop. We have considered the submissions made by the learned counsel for the contesting parties. Full stop. It is noticed that the orders passed in IA Civil number 143 of 2023 was in the matter of an insurance company praying for condonation of delay with regard to orders passed by the MSCT allowing orders passed by the MSCT, Mizoram, Aizawl. Full stop. This court had taken into account the fact that the appellants were a company having a full-fledged team dedicated to look into the legal affairs, and therefore, in the absence of mention of dates or records, was held to be against the company's prayer for condonation of delay. In similar situations, the orders dated 10/5/2018 passed in IA 131 of 2017 also relate to a case where condonation of prayers for condonation of delay by insurance companies having full-fledged backup of legal teams were taken into consideration. Full stop. In IS Civil number 134 of 2024, it was the state of Mizoram represented by the Chief Secretary who had preferred the application for condonation of delay, and this court had found that such a delay was not required to be condoned. Full stop. Next page. This court notices that the present case is an appeal against an order passed in a declaratory suit, and the applicant has stated on oath that she is the mother of a infant, and that she had to approach different lawyers in Aizawl. Full stop. Although there might be some weight in the submissions made by the counsels for the appearing for the respondents that delay may not be condoned as a matter of course, in the present case, this court finds that a liberal approach and acceptance of the explanation granted by the explanation given by the applicant deserves to be considered. Full stop. The delay of 79 days is condoned, full stop. Next para. The RFA is already registered. They given the delay is accordingly condoned, and registry to list the connected RFA in its turn on a date to be fixed by the registry.
My lord, if I may, there is another IA for stay, my lord.
That we will consider when the RFA is taken up along with the IA, not as of today. Yes.
Obliged, my lord.
Such vehement opposition and your IA being allowed is good enough for today.
Obliged, my lord.
Item 21.
Yes, 21, who appears? What is this?
Lordship, this is the criminal appeal, and it seems that a notice upon the sole respondent is not complete till now, Lordship. So we may wait for some more time, Lordship, since the sole respondent is from another district.
Against conviction?
It's acquittal, Lordship. I'm a special PP for the Union of India.
No, but this appeal is against what?
For acquittal, Lordship.
Acquittal.
Acquittal.
The office note dated 7/11/2025 reflects that the service report on the service of notice is still awaited, full stop. The learned APP is present, full stop. List after 2 weeks with service report. Yes.
Item 22.
Yes, sir.
My lord, this is a bail petition. As per the last order dated, copy is again served to the respondent. Here is the.
Lordship, I have already received the bail application. However, Lordship, I was directed to produce the updated case diary. So I seek a Lordship indulgence that this may be taken up on Thursday, Lordship. Today I'm not able to produce the case diary.
Day after tomorrow?
Day after tomorrow.
Okay.
If
Mr. So-and-so learned counsel, learned. You are appearing for the custom department?
Yes, I'm special PP, Lordship.
Learned special PP appearing for the custom department has submitted that this matter may be taken up day after tomorrow, may be taken up on
Thursday.
13th of November 2025, to enable him to have the updated CD
Possibly, yes.
as required by this court in its earlier order, full stop. List this matter again on 13/11, by which time he may obtain the updated CD.
Item 23.
Abdul Madam.
Yes.
My lord, this IA is for condoning a delay of 8 days. A notice was issued in the month of August, but my lord, the notice issued upon the sole respondent has returned unserved with a note that the addressee has left. So if I may be given a week's time to ascertain the new and correct address of the sole respondent.
The heard Mr. So-and-so and counsel paying for the applicant, full stop. The office note dated
1610, my lord.
16/10/2025 reflects that the notice issued upon the sole respondent has returned unserved with the note left, new address not known. Full stop. The learned counsel for the applicant seeks accommodation today to ascertain, to enable him to ascertain the new address of the sole respondent and submit the same before this court, full stop. List this matter after a week on a date to be fixed by the registry, by which time the applicant may furnish the new and appropriate address to this, before this court.
Oblige.
There is only one matter at 2. At 2. At 2 we'll take it up at 2. We'll sit down at 2. There is only one matter, na? And the hearing matters? Okay. ठीक है. बुला दीजिए उसको. Call him. Thank you. Yes.
May it please your lordships. This is this appeal is against the judgment and order dated 8/11 of 2023 and sentence order dated 14/11/2023 passed by Fast Track Court, Aizawl Judicial District Lordship in criminal trial number 182 of 2021. The appellant was convicted under section 21B of NDNPS Act, and she was sentenced to undergo rigorous imprisonment for a period of 5 years and to pay a fine of 30,000 in default simple imprisonment for a period of 2 months. Well, let's need problem is the PP is separate. He's absent.
What
Okay, my lords,
timing is
my lords,
2:50?
I have instruction that she is coming, my lords. She is coming. She's on her way, my lords.
She's on her way here.
Yes, yes.
Okay, I think we can proceed. You can give me
Okay, my lord.
Give us
My
your
lord,
case.
With your lordship permission, I'll read from the FIR, my lord. That is at page 2 of the paper book.
Page
2.
Where is the paper book? Yes.
To the officer in charge, Kolesip Police Station, Kolesip, subject FIR. Sir, I beg you to kindly take legal action in regards to the issue reported by me. On 10/8/2020, we received a report from a trusted source that a certain Kolesip to Aizawl Sumo service heading towards Kolesip from Aizawl via Mamit was suspected of carrying heroin. Number 4. This is in violation of NDNPS Act 1985, and I submitted an information report to the OC of Mamit PS. The OC of Mamit PS via Section 41, subsection 2 of NDNPS Act 1985 gave me authorization to perform search and seizure as required. I waited on this sumo at Mamit following up on this report. We followed this sumo till Kolesip as we have reasons to believe that the vehicle is carrying heroin. Trying to apprehend the rightful owner, we went to HB Courier, Veng Lai Kolesip on the next day, that is on 11/8/2020 at 9:30 a.m. After the sumo driver unloaded his boxes and parcels at HB Courier, a certain person named Lalthan Truami, 47, daughter of So and So of Kuang Pui Lam Kolesip, claimed a Weiwei cardboard box as hers, and she tried to pick it up. After confirming that the parcel was actually hers, we called upon civilian witnesses, namely Kolding Liana, son of So and So of Diakon Kolesip, and Ev Vanlal Dika, son of So and So, Diakon Kolesip, and opened the parcel box in presence of each owner, Lalthan Truami, daughter of So and So. Inside the parcel were tea plus and Sunday tea mix sachet, and in between it were 8 soap cases containing brown powder suspected to be heroin. Number 4. The 8 soap cases seized by us suspected to be heroin was weighed in front witnesses, and the accused owner Lalthan Truami, 47, daughter of So and So of Kuang Pui Lam Kolesip, and it was 107 grams in weight. The local market value of this heroin is estimated at 6 lakhs. It was immediately seized from the accused owner named Lalthan Truami, 47, daughter of So and So, Kuang Pui Lam Kolesip, in the presence of civilian witnesses, namely Holding Liana, son of So and So. Number 4, under section 21B, and she pleaded not guilty and claimed to be tried. And then after that, my lords, the prosecution proposed examine 6 witnesses, and the accused produced 1 defense witness, my lords. And then, my lords, the evidence, I'll read from, with your lordship permission, which is at page 11, the PW number 1. This is the seizing officer, my lords. My lord, I'll read from the deposition. On oath, I know the accused who is present before the court today. On 10/8/2020, we received information from a reliable source that the heroin number 4 has been transported by one Kolesip to Aizawl Sumo, flying from Aizawl to Mamit via Kolesip. OC Mamit PS authorized me to conduct search and seizure under section 41(2) of NDNPS Act. Pursuant to the report, I had been to Kolesip for looking for the sumo, and on 11/8/2020 at 9:30 a.m., I found that the suspected heroin number 4 packed in Weiwei carton box was unloaded at HB Courier, Veng Lai Kolesip, and left to be collected by the owner. After some time, the accused Lalthan Thuami, daughter of so-and-so of Kuang Pui Lam Kolisip, came to HB Courier and claimed that the said Wai Wai carton box containing heroin was her belonging. We opened the said Wai Wai carton box in presence of civilian witnesses, namely Golding Liana, son of so-and-so, resident of so-and-so, and F. Vanlal Liana, son of so-and-so and resident of so-and-so. And from inside, we recovered 8 soap cases containing brown powder, suspected to be heroin, along with T plus and Sunday tea packets. We weighed the suspected heroin in presence of the accused and witnesses, and the measurement read 107 grams. And the essay was also seized, and the accused was arrested in presence of civilian witnesses. The essay was packed and sealed in presence of the accused and witnesses. Arrest intimation of the accused was given to her relatives. Thereafter, I gave information to the OC, Kolasip PS, who registered the case against the accused person. Exhibit P1 is FIR and Exhibit P1A is my signature. Exhibit P2 is the arrest memo and Exhibit P2A is my signature. Exhibit P3 is the seizure memo and Exhibit P3A is my signature. Exhibit P4 is the report and seizure and arrest, and Exhibit P4A is my signature. Exhibit P5 is the authorization. Exhibit P6 is the information recorded, and Exhibit P6A is my signature. Cross-examination by DL. It is a fact that the exact time of seizure of the alleged SA was 11:40 a.m. at HB Courier, Veng Lai Kolasip. It is a fact that not a single photo of the seizure of the SA or the place PO was taken. It is a fact that at the time of arrest of the accused, there was one lady constable, but I cannot recall her name. It is a fact that I could not recall the vehicle number which transported the alleged SA, neither I know the name of the vehicle driver. It is a fact that we did not try to find the sender of the SA, but concentrated to find the owner. It is a fact that since we received a specific information that the owner of the SA was not traveling in the said vehicle, we did not take any action against the transporter or the possessor. It is not a fact that I am deposing falsely before the court. Re-examination. In respect of para 6 of the cross-examination, when we reached HB Courier, the SA was there packed in Wai Wai carton box to be collected by the owner. Now, page number 13, my lords. This is PW number 2. I know the accused person who is present before the court today. I have been elected the President Kolasip Mexicab Driver Association in the year 2019, and I have been serving till date. On 11/8/2020 at 9:30 a.m., one of my friends, BS, called me through phone and requested me to go to HB Courier at Veng Lai Kolasip. I immediately rushed to the said courier, and when I reached there, Mamit Police and the accused were already there. The police explained to me about the incident. We had been waiting for the OC, Kolasip PSN staff for a few minutes. On their arrival, we opened the carton box, YY, belonging to the accused, and inside it, we found Sunday tea mix and tea plus packets, and between these packets, they also found 8 soap cases containing suspected heroin number 4. The police weighed the heroin and the measurement read 107 grams. After weighing the heroin, the same was packed and sealed in our presence. All these steps, recovery of the SA, weighing of the SA, packing and sealing, seizure of the SA, and arrest of the accused Lalthan Thuami were done in our presence. As such, I stood as a witness and put my signature on the seizure and arrest memo. One of my friend deceased, F. Vanlal Dika, was also present when the police took the above said steps. My lords, F. Vanlal Dika, which he mentioned, was passed away before he was examined before the court. He was also a civilian witness. Exhibit P2B is my signature. Exhibit P3B is my signature. Cross-examination by DL. It is a fact that the SA was found from HB Courier. It is not a fact that I am deposing falsely before the court. Now, page number 14, the deposition of PW number 5. On 13/8/2020, we received a parcel containing 8 exhibits which were marked as Exhibit A to Exhibit H along with requisition for examination of the contents of the exhibits suspected heroin. From the OC Kolasip PS, we conducted examination of the exhibits and we found that Exhibits A to Exhibits H, that is CHE KLB so and so to CHE KLB so and so contain heroin with a purity of 82%. Each at the time of examination, we also found that CHE so and CHE so and so also contain heroin with a purity of 78% each at the time of examination. Exhibit P8 is the FSL report and Exhibit P8A is my signature. Cross-examination by Lane DL. It is a fact that the forwarding of suspected heroin was forwarded by OC Kolasi PS. It is a fact that as per the forwarding of the SA by the, this is not legible in that, but maybe that's not really
Which one?
important here. It is a fact that I am deposed fully before the court today. Page 15, PW number 7. On 13/8/2020, one of our officer SIPC Ming Tan Sanga directed me to deliver one parcel to FSL Aizawl. As it's on the same day, I delivered the parcel to the FSL and I obtained acknowledgement receipt and I handed over it to SIPC Ming Tan Sanga. I did not tamper the parcel on the way. Exhibit P12 is
Just
the
a minute, just a
acknowledgement
minute. There is a slight difficulty, it appears. Can you come to page 20?
Page 20.
The last paragraph. I examined the accused and recorded her statement. Now, this is in vernacular.
My lord, page 23, at page 23, there is a translation.
The translation is there?
23, yes, my lord.
Okay.
Okay, my lord, I'm very sorry that in the middle of the pages, some vernaculars are there, my lord.
It's okay. If it is there, it is okay. No difficulty. I was just trying to read.
Now, my lord, page 16, this is the case IO. I know the...
No, I have read the evidence roughly. You can tell me your grounds.
Okay, my lord. Now, my lord, one of my grounds, my submission is that section 42 and 43 violation, my lord. So, my lord, HB courier, so maybe a public place. So, the procedure prescribed under section 42 may not be followed, but who will conduct seizure, arrest, and search and seizure and arrest? So, that officer mentioned under sections 42 must be there. So my lord, may I read section 42, my lord?
Yes, where is that? Oh. Thank you. Section 42.
May I read? Yes. Section 42, power of entry, search, seizure, and arrest without warrant or authorization. Any such officer, being an officer superior in rank to a peon, sepoy, or constable of the departments of Central Excise, Narcotics, Custom, Revenue, Intelligence, or any other department of the central government, including paramilitary forces or armed forces, as is empowered in this behalf by general or special order by the central government, or any such officer being an officer superior in rank to a peon, sepoy, or constable of the Revenue, Drugs Control, Excise, Police, or any other department of a state government, as is empowered under this behalf by general or special order of the state government, if he has reason to believe from personal knowledge or information given by any person and taken down in writing that any narcotic, drug, or psychotropic substance or controlled substance in respect of which an offense punishable under this act has been committed, or any document or other article which may furnish evidence of the commission of such offense, or any illegally acquired property, or any document or other article which may furnish evidence of holding any illegally acquired property, which is liable for seizure or freezing or forfeiture under Chapter 5A of this Act, is kept or concealed in any building, conveyance, or enclosed place, may, between sunrise and sunset, enter into and search any building, conveyance, or place. In case of resistance, break open any door and remove any obstacle to such entry. My lords.
Which one?
Now I'll skip this part, my lords. Now coming to section 43, my lords. This is the public place, my lords.
Okay.
Any officer of the departments mentioned in section 42 may. This is why I wanted to point out, my lords, because this may be a public place.
Which one?
Section 43. Any officer of any of the departments mentioned in section 52. So he has the power to seize in public place, my lords. So as per section 42, my lords, the state government had issued a notification which I had given to the courtmaster, my lords. Notification dated the 2nd of July 2018, my lords. dated Aizawl the 2nd July 2018, number J such and such. In continuation of this department's notification, number B so and so, date so and so, and in exercise of the power conferred
Okay,
by
under the respective jurisdiction.
under the respective jurisdiction.
Okay.
My lords, there is an RTI reply. I have given.
There
a
is
copy,
no
my lords.
jurisdiction of
Yes.
the Mamit police to go
Yes.
into?
Yes, my lords.
that place.
My
Okay,
lords,
then?
the first word is Mizo vernacular. The next at the next page, English translation are there, my lords. So there are 14 villages under the jurisdiction of Mamit Police Station, my lords. Kolasip is beyond that
Kolasip is
jurisdiction, my
beyond
lords.
that, yes.
So, my lords, to support my submission, I have one authority. That is Roy Vidi versus State of Kerala. Citation is 2000, volume 8, SCC, page 590. The relevant paragraph, operative parties at, my lords, para 16.
1-6.
Yes, my lord.
No officer and employer can resort to 41-2. 42-1.
Now it is plain that no officer other than an empowered officer can resort to section 41.2 or exercise powers under section 42.1 of the NDNPS Act or make a complaint under clause D of subsection 1 of section 36A of the NDNPS Act. It follows that any collection of material, detention or arrest of a person or search of a building or conveyance or seizure effected by an officer not being an empowered officer or an authorized officer under section 41.2 of the NDNPS Act lacks sanction of law and is inherently illegal, and as such the same cannot form the basis of a proceeding in respect of offences under chapter 4 of the NDNPS Act, and use of such a material by the prosecution visits the trial.
Can you tell us what happens in a situation?
My lord, so he is not the authorized officer.
Okay.
So he came from Mamit police station and then
Goes
arrested
into
and seized.
Kolasip
Yes,
and-
yes. And then even if he had exceeded his jurisdiction, anything material collected cannot be used for evidence, my lord. That the trial is vitiated, my lord.
Uh-huh.
That the trial is vitiated.
How?
Because he is not an authorized officer. He is not an authorized officer to conduct search and seizure at Kolasip. Because he is not his jurisdiction, my lord.
No, does this court speak of such a jurisdiction? Where does it say? In this case that you have referred to, where do we find that it was done beyond his jurisdiction?
Well, it's, the Supreme Court specifically dealt with who are the authorized officer.
No, that I have understood, that if an officer is not authorized, then he will not do it. So now suppose a person does not have the authority of the central government or any such officer of so-and-so, 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 or any such officer of the revenue drugs and so-and-so, officer government as is empowered in this behalf by general or special order of the state government if he has reason to believe. Then you come to number section, any officer of the department may so-and-so. So you are saying that
Yes.
this empowerment of doing
Yes,
something is
has
only
been-
within that jurisdiction?
Yes, has been notified under section 42 of the NDPS Act, my lords.
Okay.
That is my first
One
submission, my
ground,
lords.
yes.
My next submission is that, my lords, regarding the section 52A violation, my lords.
52.
Section 52A.
A.
My lords, I'll read subsection 2.
52A subsection, yes.
Subsection 2, where any narcotic, drug, psychotropic substances, controlled substance or conveyances has been seized and forwarded to the officer in charge of the nearest police station or to the officer empowered under section 53. The officer referred to in subsection 1 shall prepare an inventory of such narcotic, drug, psychotropic substances, controlled substances or conveyances, containing details relating to their description, quality, quantity, mode of packing, marks, numbers, or such other identifying particulars of the narcotic drugs, psychotropic substances, controlled substances, or conveyances, or the packing in which they are packed. Country of origin and other particulars are as the officer referred to in subsection 1 may consider relevant to the identity of the narcotic drugs, psychotropic substances, controlled substances, or conveyances in any proceedings under this act, and make application to any magistrate for the purpose of certifying the correctness of the inventory so prepared, or taking in the presence of magistrate a photograph of such drugs, substances, or conveyances, and certifying such photographs as true, or allowing to draw representative samples of such drugs or substances in the presence of magistrate, and certifying the correctness of any list of samples drawn. My lords, in this regard, I'll stop here. There is no such application before the magistrate. As per section 52, subsection 2, my lords, the officer, the concerned officer must prepare inventory, and after that, he shall submit an application to the magistrate for the correctness of inventory and taking photograph, and allow to draw samples. My lords, in this regard, if I may kindly take your lordships to page number 86. Page number 86. Page number 86, my lords. This is the inventory. And then under this, my lords, there is only a certificate. There's only a certificate. There is no application submitted before the magistrate, my lords.
Applied to me?
So that application has not been found, my lords.
You say that the application should be only an application in a particular form,
yes, my lords,
making a particular prayer.
Exactly.
And that prayer cannot be oral or something.
Yes, my lords. And my lords, while we are in the page number 86, my lords, at the left side, my lords, the date mentioned is 12/6/2020.
12?
To 2020. That is before the arrest and seizure.
No, 12/8.
So
where do you find 12/2?
At the left side, that is at page 86, my lord.
No, that is what I'm not finding any 12/2.
12/6, my lord.
Ekdam down below.
Yes, yes, my lord. There are two
Typo.
12/6.
But look at the signature.
Yes.
Look at the signature.
Okay, my lord.
Just below the signature, what is written?
We cannot say, my lord, which
No,
one is the correct one, my lord.
Look at the signature.
Okay, my lord.
Is it 12/8? It is 12/8, no?
Maybe a typing mistake, but there is no explanation for this one, my lord.
Okay. Okay.
And my lord,
was this ground of jurisdiction taken before the trial court?
My lords?
Was the ground of jurisdiction argued
Yes,
before the trial court?
It is that has been dealt with by the trial court, which is 42 violation, my lords. It's
What did
clearly
it say?
mentioned in the judgment, my lords.
What did it say?
So because there is no violation of section 42, my lords.
Only that much?
Yes, my lords.
There must be some
yeah,
issue.
it has been dealt with, my lords. My lords,
Where? Okay.
my next submission
Yes.
is that section 55 violation, my lords.
Section 42, 43, then you say 52 A2. Then you say
55, my lord.
5. Okay.
This is regarding the safe custody of the seized article, samples. Police to take charge of articles seized and delivered. An officer in charge of a police station shall take charge of and keep in safe custody, pending the orders of the magistrate, all articles seized under this act within the local area of that police station and which may be delivered to him, and shall allow any officer who may accompany such articles to the police station or who may be deported for the purpose to affix his seal to such articles or to take samples of and from them, and all samples so taken shall also be sealed with the seal of the officer in charge. My lords, here there is no go down receipt submitted before the court, which is not exhibited And then the acknowledgement from the go down in charge was also not there, not exhibited, my lords.
Absence of receipt by go down.
Yes.
No.
And then go down register.
Register. Go down register. Okay.
So, my lords, in this case, my lords, the sample was drawn on 12, and then it was sent to FSL on 23. The seize was effected on 11, and my lords, there is nothing on record to show that in whose custody the SA was there and the samples was there, my lords. And then, my lords, in this regard, I have one reference and coordinate bench of this court judgment in Lalsang Vunga versus State of Mizoram. Citation is 2021, volume 4, GLT 988. And the relevant para is para 28, my lord.
28.
28, 28, my lord. My lord, I will not read the entire paragraph, my lord. This specifically deal with the custody of the assay samples and the sample seal, my lord. And my lord, another one is also coordinated bench of this court judgment. My lord, because why am I referring is that, my lord, there is some slight difference in the words used in these two judgments, my lord. That is Chanam Ranjit Meitei.
So in this one, it is paragraph 28, which says, it was therefore not proved that the seals found on the sample package were the same with the sample seal.
Yes.
Register, appellant found to be entitled to be given. Okay, this is para
And then
28.
the next one, my lord, para 23, Chanam Ranjit Meitei.
Para 23. Yes.
Now herein, my lords, also, it specifically deals with sections 55, my lords. And if it is not followed, prejudice has been caused to the accused, my lords.
So where do we find from the statement of the prosecution that it was not done?
No, my lords, the prosecution did not.
What about this prosecution witness number 7?
PW7 is the messenger, my lords. On 13, the OC sent to deliver the samples to the FSL Aizawl. So what I'm trying to point out is that, my lords, on 11th and 12th night, where is the assay and samples, my lords? So that the prosecution has to prove that it was in safe custody, my lords.
Okay.
And my lords, and my next submission is that this is regarding a violation of the Spending Order 1 of 1989, which is issued by the Ministry of India, Ministry of Finance, my lords.
Violation of Standing Order?
1 of 89.
1 of 89?
Yes, my lords.
So much of time has passed, people
Yes,
have
but,
become so much smarter.
My lords, after this, my lords, the new order has been issued only in 2023.
Okay.
My lords, the relevant section is section 3.1. Page 1.
3 point?
No, my lords, 2.3 before that, 2.3. Page number 2, my lords. If I may read, my lords.
Shall not be less than 5 grams.
5 grams, yes, exactly,
Okay.
my lords. So, my lords, in this regard, is if I may kindly take your lordship to page 87A. 86A, my lords. That is the sample drawn.
80?
86A.
6A.
That is the list of sample drawn. There are 8 from each
Just a minute,
packages.
Just a minute. 86.
You lordship have it.
Hmm.
From each soap cases, my lords, from 8, 2 samples were drawn from each packages. But my lords, the quantity, the weight, the samples were not weighed. So, and then we can find that as per the FSL report, that is at page 84, my lord.
84.
The samples, all the samples are less than 5 grams. That the maximum one is 1000 mg. That is only 1 gram.
Where do you find it? Page 80?
Page 84, my lord.
How much is required? 5 grams.
5 grams, my lord.
So these are all milligrams.
Yes, my lord. And my lords, that next is regarding the section 3.1, that is the standing order. 3.1, my lords. At page number 2. After sampling, a detailed inventory of such packages, containers shall be prepared for enclosure with the panchnama. Original wrappers shall be also be preserved for evidentiary purposes. This is why I like to point out that, my lords, that the original wrappers is YY carton box, my lords. This is not produced before the court, not exhibited, my lords. That is why it creates a doubt about
Now this violation of these are procedure.
Yes, my lords. So
These are procedure.
yes, my lords.
How far they will affect the merit of?
Yes, my lords. So I will come to that, my lords. I have one authority, that is
Okay.
in Nur Ga case, my lords. And my lords, that next one is section 3.2. All drugs shall invariably be stored in a safe and vaults provided with a double locking system. Agencies of the central and state governments may specifically designate their godowns for storage purpose. The godowns should be selected keeping in view their security angle, juxtaposition to codes, etc. Such godowns, as a matter of rule, shall be placed under the overall supervision and charge of a gazetted officer of the respective enforcement agency, who shall exercise utmost care, circumspection, and personal supervision as far as possible. Each seizing officer shall deposit the drugs fully packed and sealed in the godown within 48 hours of such seizure, with a forwarding memo indicating NBNPS crime number as per crime and prosecution. Under the new law, name of the accused, reference of the test memo, description of the drugs, total number of packages, containers. 3.4, the seizing officer, after obtaining acknowledgement for such deposit in the format, shall hand over such acknowledgement to the investigating officer of the case, along with the case dossiers of further proceedings. So, my lords, these were not done, my lords. Go down receipts were not taken from the go down in charge.
So you are basically saying that the product which was said to have been recovered from you,
yes,
it did not receive the due due care that should have been given. That should have been given by the prosecution,
my lords,
to maintain its sanctity.
Yes, my lords.
And since it was not done, it was not sent properly to the godowns, and the receipts were not. So we cannot say that the same material which was recovered was the material which was exhibited or which was sent to forensic, and therefore there is a doubt as to whether these were the very materials which were recovered by, are recovered from you, if any.
Yes, my lords. And then to ensure that there is no tamper with at all. There is no tamper with at all, the essay and the samples also.
There is no tamper and nothing is given, okay.
If these documents were not found, we cannot say that the samples and all those things were tampered with. We cannot say that, my lords.
Let's go down, since it was not kept properly, from the time of seizure to the time of sending it to the forensic.
Yes, my lords.
So therefore, Okay, there is a doubt.
And my lords, that's it regarding the standing order, my lords.
Uh-huh.
And then, my lords, my next submission is that the sumo driver, my lords, he was not cited as prosecution witness. So that seizing officer that in page 11, my lords, no, page number 12, in his cross-examination, clearly stated that he did not know the sumo driver, and that the sumo number was also not known. So, he, my lords, he is the one who transported this article, as per the allegation, my lords, from Aizawl to Kolasip via Mami. So, he will explain all these things. He will unearth the prosecution's story. So, my lords, but this witness, material witness, has been withheld by the prosecution, my lords.
But that is to their, that is at their risk. They are not bringing that man.
My lords,
Yes.
because, my lords, what I am trying to point out is that, my lords, if the driver was examined, he could clearly mention how many Weiwei parcel box he carried from Aizawl to Kolasip. And then maybe, assumption, some passenger may exchange all those things, Weiwei parcel box. So we cannot say that, my lords. So this material, important material witness has been withheld. So if he has been examined, my lords, he will unearth the truth, my lords. So it may go against the prosecution also, my lords. My lords, in this regard, my lords, I have one citation. That is Parminder Kaur versus FPP Kaur versus State of Punjab, my lords. Citation is 2020, volume 8, SCC, page 811. Operative part is para 15, my lords.
Yes, para 15.
Yes, my lords.
Non-examination is a
Yes, my
noticeable
lords.
lapse given in the prosecution story. That is what I said, if they have not examined someone, it is at their risk they have not examined it. That will be to your benefit.
Yes, my lords. So in this case also, my lords, Ban Singh and Karnal Singh, they were standing outside the door. Well, the prosecutrix was bolted inside that room. Well, he ran away, my lords. These two persons were standing there, but they were not examined. So that's why benefit of doubt has been given, my lords.
Okay.
And my lords, and my next submission is that, my lords, the deposition of the case IO and the deposition of the seizing officer is different. There is a contradiction between the two, my lords.
What?
So yes, my lords, in this regard, my lords,
That huge paragraph, is that the one? They checked it sumo, then the sumo, it was raining, they went away. That one?
No, my lords, I have one. My lords, if your lords may kindly come to page 18.
18,
Yes, my lords.
That is what I am saying. 18.
This is the deposition of the case IO. Page 18. If I may read, your lordship.
The said sumo reached highway junction, and while we were to check the vehicle, it rained heavily. As there was no proper lighting, we were unable to search the sumo, and we took the sumo to Mamit police station. That one?
Yes, my lord. After reaching Mami PS, along with our superiors such as additional SP, SDPO and OC, we saw the parcel that was believed to contain intoxicants described. We, however, believe that the actual owner was not present in the vehicle, and as instructed by our superior, one colleague of mine and I headed towards Kolasip.
So if the vehicle was taken to Mamit police station,
first,
there
my
would be...
lords. Yes. Vehicle was taken to Mamit police station first.
That is not
And
by
this-
any other witness.
Yes, this was that the essay was recovered first. And then after that, they loaded it in the sumo again and then taken to Kolasip.
No, it
And then,
wasn't
my lords,
recovered, they noticed it.
That is the deposition of the case IO. My
No,
lords,
we saw the
regarding-
parcel. We saw the parcel. He's saying we saw the parcel. They don't say we recover it. They saw the parcel, allowed the vehicle to go ahead so
Yes.
that they can catch the main person who was.
That is as per the statement before the case IO. The seizing officer's statement before the case IO. So the case IO reiterated it herein. So my lords, regarding the position of the seizing officer, that is at page 11, my lords.
Huh?
Page 11, my lords.
He does not say about going to the police
Yes,
station.
my lords. So he was looking for the sumo. So there is some serious contradictions between the two, my lords.
It's not a contradiction. There are some cases where the witnesses, they try to make a better story. And there are some cases where the witness tries to edit a story. So here he has edited it. What he said to the investigating officer, he did not say to the court that we took it to the police station. For whatever reasons, he did not say it.
And my
Yes.
lords, regarding there is no thorough investigation. The investigation was taken lightly, my lords. So as per the cross-examination of the PW1, the seizing officer, that is at page number 12. So the sumo, they did not know the sumo driver, and the sumo number was also not known. They did not try to find out who is the sender. And then that is my
So you are also that driver
Grounds-
was
one grounds,
driver, not produced, and contradictions. Anna?
Yes, my lords.
Contradictions, yes.
And my lords, my last and humble submission is that regarding the PW number 2 deposition, my lords. PW2 deposition, if I may read again, my lords. On 11/8/2020 at 9:30 am, one of my friend, BS, called me through phone call and requested me to go to HB Courier at Veng Lai Kolasip. I immediately rushed to the said courier, and when I reached the tree there, Mamit police and accused were already there. So they were already there, my lords. After the seizing officer's deposition, the accused claimed to be harsh, that parcel. But this civilian witness did not say about this, my lords. So, and the next line, my lords. The police explained to me about the incident. So all the incident, so then maybe they say that...
So that
Yes.
this lady did not acknowledge that the bag is hers or the parcel is hers before this witness.
Yes.
Everybody was already there, he went there, and after that police explained this has happened.
Yes, yes.
And then,
Yes, my lords. And then
so he was almost tutored.
And in her, he went his statement also. So she denied all the allegation against her. And my lords, this one is also then she stated that, my lords, so that parcel, she was trying to collect his contained shoes. So that the contained shoes, she clearly explained that, my lords. So she did not accept that it will contain heroin, my lords. That is how she wanted his statement, my lords.
She was saying she wanted some shoes.
Yes.
So
And
tell
then-
me one thing. Suppose the police authorities here in Mizoram find a very known criminal and starts chasing him, and he crosses the boundary of this district or the state, goes into the next state. Mizoram police doesn't have the... Then what happens? That man is free. He can just jump the border and say that, look, you can't touch me now. Can that be? Because you are saying that police from Mamit did not have the jurisdiction in Kolasip. So now this car was going through Mamit and they were trying to find out the actual person. They waited for that Kolasip police to come.
Yes, they will.
But
call
this
the police to
person
come.
who is chasing that man, who is chasing a crime,
Yes, my lord.
can he be made to stop at a border and say that no, you don't have any further jurisdiction? If it is a country, it's a different thing. You can't go from here to Bangladesh or to Pakistan or to China maybe or to Burma to chase a man. International law will stop you.
Well, yes.
But narcotics being what it is, psychotropic drugs being what it is, can we still say that a man cannot chase someone beyond the territorial jurisdiction over which he has the authority?
Yes, my lords, they can chase it, but my lords, they requested the
Scholarship to be
police
there.
jurisdiction to arrest and search seizure. So that is the usual practice, my lords. So
No,
big- yes.
now I am chasing someone.
Yes, my lords.
He is there immediately before me. Do I still wait to take permission from someone? It comes and then I go and I arrest him or I confiscate him. Will he not flee by that time? Or do I keep chasing him? If I am chasing him, I cannot go for permission. If I am going for permission, I cannot chase him. So what choice do I have then?
My lords,
What
that is
to
the
do?
difference. So that's the central government, DRI is there, customer there, they have jurisdiction here throughout India. So they can chase, but according to that notification, that totally different, my lords. So that officer, they believe that at Mamit police station also, my lords, they believe that the parcel contains heroin. So they can inform the scholarship police to do something for finding.
No,
the,
what they could have done is one thing.
Yes.
What has already been done, is it wrong?
Yes.
What we have to see is what has been done, is it wrong?
Yes, my lords.
What different way it could have been done, there will be 100 ways of doing it. 100 more ways of doing it perhaps. We cannot think of every possibility. But what has been done in this case? That particular part where this man was, they were constantly behind this parcel. And when the opportunity came, they detained everyone, asked the Kolasip police to come. The arrest was effectuated. Only that part. Why is it wrong? If I am chasing someone, I am chasing someone. It is within my state territory.
My lords, he has ample time. That seizing officer has ample time. He was waiting for the person to come and collect that person, my lords. So there is so much time to...
No, that is what they are
Yes.
saying, that they will be waiting for the OC Kolasip to come.
Yes.
Now, if they are waiting for the OC Kolasip to come, definitely there must have been information prior to that. Now, OC Kolasip is not reaching. What does he do with the men?
Yes, my lords.
He
That
has
is
to
the-
catch hold.
yes, that is
He
the
has
key.
to arrest. You have to show us what is wrong in that. Other part we will look into that, go down receipt and not putting up the appropriate
My lords,
stickers.
in my humble opinion, my lords, in my understanding, my lords,
Yes.
so he has a right to chase everywhere, everywhere, even outside the
Jurisdiction.
outside the jurisdiction and even outside the state of Mizoram. So, but that, my lords, if the law does not authorize to effect that arrest and seizure, so he has to request, he can detain. So he has not to sign that formal, the formal.
He
things, my
cannot
lords.
sign it.
Yes, yes, my lords.
He should have asked the other persons to sign
Yes,
it.
that is the thing, my lords.
Okay. Anything more?
No, my lords, that is my humble submission. One citation regarding the violation of the standing order and all, and then regarding the samples also, my lords. I have one citation, that is Noor Aga versus State of Punjab.
And this is regarding?
Regarding the standing order violation and the safe custody of the samples and all those things, my lords.
Yes.
So many things are dealt with it, my lords. So, my lords, the relevant para, sir, from para 1, 2, 3 to
1, 2, 3.
no,
123.
123, my lords.
123
to 137.
137. Okay.
I will not read out, my lords, because it's a long. I will take time, my lords.
We will try to read.
So, my lords, my humble submission is that from my submission, I humbly pray your lordship to set aside the impugned judgment and sentence and to acquit the appellant in the instant case, my lords.
When was it? It was in 2023. 5 years, 23, 2 years gone. When, since when is he in custody? Was he released in between?
Yes, my lords. During the trial, she was released on bail. And then after the conviction, she is being kept in jail till date, my lords, since 2023,
2 years gone.
my lords.
Incident is of 2020.
Yes, my lord.
Okay. Yes, madam.
Please, Your Lordship. Your Lordship, we know that it's a subtle principle of law that in ND and PS Acts or say POCSO Act, it's a special legislation wherein there is a reverse burden of proof. Now, before that, prosecution has to stand in its own legs, and then we have to prove the foundational facts, no reasonable doubt. Now, in that regard, before I go replying what my learned friend have submitted, I will just take Your Lordship kind attention, with your permission, to the conscious possession, which was duly proved, the foundational facts, which is duly proved by the prosecution before the learned trial. Your Lordship have already pointed out the vernacular language, which is in page number 25. The translation is in page number 23. This is the deposition of the who is it? PW number 8. Here's the case. Yes, he's the case IO. And the case IO, in his examination in chief, the translation, with your Lordship permission, may I read?
English
Page
part,
23. I examined the accused, so-and-so, and recorded her statement, to which she stated on 9/8/2020 at around 3 p.m. A person that I used to know from Zokotar named Zai. Zokotar is the Your Lordship, the border village of Myanmar and Mizoram, wherein all sorts of commercial transaction has taken place. Named Zai gave me a call. She said, I will send you some number 4. Number 4 is heroin. Will you help me sell it? I do not know where she is right now. However, I do know that she is from Zokotar area. She again called me on 10/8/2020 and said, I am sending it through Jongtae Sumo on an empty YY card box. On an empty YY card box. Addressing it to Mami Kolasi. It's very clear. She even sent me the Sumo driver's number. I called the driver this morning, who, however, said, I did not carry your parcel. It is carried by Mayflin drivers instead. I again called up Mayflin driver and asked if he carries a YY parcel labeled Mami on the outside. He confirmed that he carried the parcel and he asked me to collect it from HB Courier. I'm stressing on YY empty carton box and HB Courier. And upon reaching HB Courier, I asked the shopkeeper if my YY box parcel labeled Mami has reached. As it has not reached yet, I went home again after he called the driver. On my way home, I saw Mayflin Sumo and I asked if I can collect the parcel there. The driver, however, asked me to collect it at HB Courier and he drove ahead. I went to HB Courier from Bangtar and upon reaching, I asked the shopkeeper if my parcel labeled Mami Kolasib has already reached. She replied that it has, and when I was about to collect it, one person who was sitting inside the shop said, we believe that there may be drugs inside. Wait for the police. We waited for the police and when they reached, they opened the parcel in my presence and inside it, they did find heroin, number 4. So what I would like to point out from here is that, Your Lordship, she have the conscious possession, the control over the person. She knows the content. Now coming to the cross-examination, this is not shaken. This is not shaken. Nothing is, per contra, nothing is adduced before the learned trial court against this. And if I may take Your Lordship kind attention to the 313. which is in page number 5.
This was witness number 8. Cross of PW 8. Okay. Not shaken.
It is true that in her 313 she have denied, plainly denied. But then she have 2 witnesses before the learned trial court. But then it's of no relevance. If I may take your lordship kind attention to the evidence adduced by the DW number 1. DW number 1 is in page number 27. Sorry, only one
Only one.
one defense witness, yes. Your lordship, may I read with your permission? This is the examination in chief. I acknowledge that unknown person from Aizawl had called my friend Tantuami that they have dispatched and women's shoe which should be delivered to Tantuami. Nothing, no specific. And cross-examination, number 1 is important. It is a fact that an unknown person from Aizawl never told me that the parcel which she was about to send contained shoes. So it's of no relevance.
Just a minute. When is that reference? 345 or 315? Huh? 330 is the reference. So you have to rise at 315, na? Okay.
I'll try to conclude it by 15 minutes.
We can continue later also.
Yes.
Necessary.
And
No, about this, what do you say about this part that the officer who arrested would have no jurisdiction to go into?
I'll come to that, Your Lordship. Your Lordship, if I may take Your Lordship kind attention to page number 11. This is the deposition of prosecution number, witness number 1. This is the seizing officer. In the 3rd paragraph, this is all to prove the conscious position. The accused, Lalthan Tuami, on the 4th line, the accused Lalthan Tuami, daughter of so-and-so, came to HP Career and claimed that the YY curtain box containing heroin was her belonging. And in cross-examination, Your Lordship, this is not shaken. If Your Lordship wish to, I can go to all the cross-examination, but then it is not there.
Read, huh?
Yes.
You have read it, huh?
So, Your Lordship, beyond reasonable doubt, the conscious position is proved by the prosecution before the London Trial Court. In this regard, may I submit an authority, that is 2025 SCC online SC 122, para 21.
Para?
21. And 22. This explains the meaning of conscious position and how the reverse burden of proof falls on the accused. In our case, the accused, that is the present appellant, have deliberately failed to prove as to how that seized article came into her possession, even though it is on record.
That is why I was going back to what he had submitted. Let us presume that the prosecution was able to prove that this particular YY box, she knew it contained heroin, it was found with her, so it's a conscious possession. But to establish that it was heroin and she knew it was heroin, the basic fundamental which had to be proved was that heroin was recovered. Some person standing up and saying that yes, this box is mine and it contains heroin will not make him liable to prosecution or anything else. Now to prove that that box contained heroin, it had to be sent for the test in the manner prescribed by law.
Standard.
by a person who was prescribed by law to do so. If these two things fail, then whether she possessed that box or not, when the content of that box does not remain proved, whether she possessed it consciously or it was an unconscious possession or beyond her imagination possession, doesn't matter. If the product itself is in doubt, whether it is talcum powder or whether it is heroin or whether it is some other thing. His case is that the seizure was not correctly done. It was not correctly put before the godown. It was not correctly tested. We do not know what was tested. And therefore the conclusion that it was heroin, that goes. If that goes, her possession
Correct. I'll come to
doesn't
that.
matter.
I'll come to that. Your Lordship, if I may take Your Lordship kind attention to page number 78. This is the page 78.
Otherwise, your submission about the conscious possession, that will come in immediately when we can say that it was heroin.
So, this was exhibited before the learned trial court.
Which one? Page?
Page 78.
Page 78 is what?
Enclosed.
Ah.
Written 1, 2, 3, 4.
Yes, yes.
This is the number 1 is information report, authorization letter, seizure memo, arrest memo, so and so. On 8, forwarding letter of samples. Sorry, report of seizure, status of complainant. Forwarding letter of samples to FS. Certified list of sample drawn. Copy of certification. Application for certification. My learned friend before said that there is no application for certification. Just that certification is there. But then it was without the application.
Even otherwise, that when the magistrate signed saying that it was applied and I certify, it is not the application which is important, it is the certificate which is important. So that we may be not very impressed about on that point. But
Your Lordship, with regards to the whereabout of the heroin, if I may take Your Lordship kind attention to page
no, what was tested in the forensic laboratory could have been heroin, we do not doubt that. Thing is, the process which was required to be followed while sending it to the forensic test, whether that was maintained good enough for us to assume that that product was taken from that bag, that very thing was tested and that very thing was found to be heroin. So the procedure laid down is there must be an inventory, there must be a proper sampling, those 5 grams and 20 grams and whatnot packets are to be made, that is to be tested.
Yes.
We do not find that in the record.
If I may take Your Lordship kind attention to again to the prosecution witness number 8, that's the case IO evidence, which is in page number 22. In this,
22, we'll have to read somewhere thereafter.
page number 22, the first paragraph starts with the arrested person. Now, in the fourth line, Your Lordship may see the sample.
No, page number 22, the arrested person was forwarded for judicial custody. Drawing of sampling was done before.
The sample drawn from exhibits marked as sample A, B, C, D, E, F, G, and H. And Your Lordship, for the purpose of whether was forwarded to acknowledge.
So, is it a case where you are trying to say that it was not even sent to the godown?
Your Lordship, I'm coming to that.
Then it has to go directly.
Your Lordship, first, I will try to rephrase my submission. Page number 21.
Okay.
The first paragraph. The first paragraph starts with during the course of investigation. Now these are all the examination in chief. This fourth line, the seized articles were kept at a designated storage Malkhana by policy PS station Malkhana register number so and so, dated 11/8/2020. after thoroughly verified by the OC Colosseum for safe custody. Now this is intact. Then this is kept in the Colosseum Malkhana, and it bears the register number 49 of 2020. And Colosseum PS case 59 of 2020 was registered, dated 11/8/2020.
And arrested by Kolasi PS.
Yes. And then on the next page, on 12/8/2020, sample was drawn before the judicial magistrate, and it was marked as A, B, C, D, E, F, G, H. Now, if I may first take your lordship kind attention to the FSL report, which is in page 84. Now, it bears in the first paragraph, your lordship will see that now it was submitted before, it was submitted in page number 22 that A, B, C, D, E, F, G, H, and it was sent to the director FSL and escorted by Constable 120 Biakropiam. Now, here the sample drawn is A, B, C, D, E, F, G, H. I'm not talking about the quantity. I will come to the quantity later on. Now, the Colosseum case that is registered is 59 of 2020 in the first paragraph. You can see that.
Yes.
So we can see that there is nothing to doubt about. And your lordship, it was after that it was sent for FSL, and one Biakropuya constable in page number 15 have deposed before the learned trial court that he was the one who delivered to FSL.
Yes, yes. Whom he called a messenger.
Yes.
That is the person, yes.
So there is nothing to doubt as to the whereabout or the storage of the seized articles. Now we see that it was properly drawn before the learned magistrate, and then it was properly sent through a messenger, that is a police constable, which was examined before the learned trial court. So there's nothing to doubt about it. And all these things that PW number 8 have elaborately listed in the examination chip is not shaken in the cross-examination. Now, yes, coming to the standing order, your lordship, we know that for heroin, minimum, a standing order, a minimum of 5 grams has to be drawn for a sample. Now, we know that in NDNPS Act, non-compliance of Section 42, etc. will violate the trial. But then this standing order is not a mandatory provision of law which will violate the trial. It's a standing order which have to be nicely requested so as to be followed. Your lordship, I'm not saying that it's not an empty protocol or procedure that has been laid down by the authorities. Yes, it has to be followed. But then mere non-following of the standing procedures will not violate the trial when there is a cogent evidence against it.
Moreover, this 2.3, as we are seeing it, 24 grams is required for a chemical test for opium, ganja and charas.
Yes.
So that is the minimum quantity available, but it does not say that 5 grams is the minimum required for the test. If the forensic laboratory can test it on a... Okay, then...
And, your lordship, my second argument as to regards to the standing, non-compliance of the standing order, etc., is that, yes, it might not be. The 5 grams was not thrown. We know that. But then this page 84, which is the the FSL report, was duly exhibited before the learned trial court. Now, in I do not know in BNSS, but then in CRPC, section 293, if I'm not mistaken, the opinion or the reports by the expert is to be taken as an evidence by the court.
Yes.
And this was not challenged, was not raised.
This ground has not been
Yes,
taken.
yes. And then unless this is challenged, the report is challenged, then this has to be taken into account. Now, that proves that the seized article contains furon. Because in page 85, the results of examination clearly shows that it contains 78% purity of furon.
In one case, I think it is 90%, 89%, very nearly 90. 82 or something. Yes.
And with regards to the non-examination of the sumo driver, Your Lordship. Yes, this is the ground taken by my learned friend. However, Your Lordship, as I have already cited earlier, the reverse burden of proof is already on the accused, first of all. Second is that it was from routing back to the evidence of the seizing officer. We know that she herself has stated, which was not shaken in the cross-examination, that YY box, carton box, which she said contains heroin, was sent from Zolkatar, and she traced it to the HB courier as per the information received from the sender by her. And then it was her who claimed that the box is hers, it belongs to her. So there is no necessity which give rise to the examination of the sumo driver. Just one more point, Your Lordship. With regards to non-examination of, I think I have gone through, the jurisdiction, only the jurisdiction I will answer to that. Your Lordship, as per the RTI which my learned friend has furnished at this stage, it was asked in the year 2024. Now, all the incident happened way back in the year 2020.
So
Now,
this
this question is not relevant. I'm not saying that it is not their jurisdiction. I'm not saying that it is their jurisdiction also.
But this will not have
RTI
relevance.
on record, yes. And the learned trial court have answered these questions as to whether it's proper or not in the from page number 38. This is the third question which was determined point of consideration. The learned trial court has elaborately in 3 pages have stated that there is mandatory provisions is complied with and there is no violation of jurisdiction, etc. So this is my answer. With that, Your Lordship, with the impact that the drugs have on the public, then I'll just rely on one more case with regards to section 52A. This is just one case, Your Lordship. My learned friend have cited the 52A is not complied with. In this regard, it's 2024 SCC Online SC 3848. It's NCB versus Kashi. Page paragraph 39. Sapara 3. N4.
No, 39 does not have any subpara.
Yes.
Okay.
Sorry, close. Sorry. Not subpara, close. Para 39, subclose 3 and 4.
No.
What I would like to rely on is that in para subclose 4, it's in page number 20, Your Lordship.
No, we have, it's Kashif, it is 2024 11 SCC. They've given me the 11 SCC printout. What is this? What is that start with, the sentence?
It's in the in the upshot of the above discussion may be summarized as under.
Upshoot. Discontinuation.
It will be from, I think, last or second last.
In our opinion, none of the provisions at this stage. The upshot, yes, para 50.
Yes. The subclause 4, 3 and 4. I'm going to rely on 3 and 4, but then since I'm going to conclude, I'll just read out with your permission the subclause 4. Section 2 of 552A lays down the procedure as contemplated in Section 1. Therefore, any lapse or delayed compliance thereof would merely a procedural irregularity, which would neither entitle the accused to be released from bail nor would vitiate the trial on that ground alone. So I will rely on that. In that regard, with to sum up my argument, Your Lordship, my prayer is to uphold the findings of the learned trial court and uphold the judgment in order passed by the learned trial court.
We will keep this matter for Friday.
Okay.
We'll take this matter up again on Friday. And just try and see if any one of you can find out anything about the hot pursuit concept. When there is a hot pursuit, what do you call it? The hot pursuit, what does it mean?
Yes, yes. It's
Chasing
natural
someone.
way, yes.
That is why I was asking you again and again.
Okay, I have that.
If this is a concept of hot pursuit where this man had to chase and catch, then is it permissible? I'm not saying it goes against you, I'm not saying it helps the prosecution. What I'm saying is the concept of hot pursuit may come in when a man takes a permission to chase someone from his jurisdiction and has to enter some other jurisdiction. Then what is the law? Because if he has complied with that part of the law, perhaps your argument will have to be weighed otherwise. But if whatever law is there for the hot pursuit concept, then that part of the argument may have some weight. So we'll keep it on Friday, or let us also see if all the arguments of the appellant can be evaluated. So we'll keep it, this again on Friday as a part matter. Part 1 list, yes. As part hard. We'll take it up as part hard. Okay, we have to rise because there is a reference.
Yes.
Thank you. There was one matter in the part 1 list. Any leftover matter was there? No.